Hi, Franz.
Brian Kennedy.
Brian, nice to meet you.
Good to meet you.
I'm Kiersey.
Kiersey, Brian.
Brian, pleasure.
Good to meet you.
Well, Brian, thanks for coming in and meeting with Kiersey and I. We were kind of reflecting on this. It's amazing how some of these complex construction jobs, there always seem to be little issues, but at the end of the day, the building always ends up getting built. You never see a half-built building in the world.
Well, I think I'm glad we got a chance to sit down. I know that it's incredibly important to both of us that we end up with that fully built building and built to the high quality we all wanted.
Two of them, in fact.
Actually, two of them. That's true. The whole construction project.
Yeah.
It's nice that we can sit down. I think that we have some rebuilding of trust we want to get with. We want to make sure that we move forward, and I think that we're going to end the day with an understanding and move forward and finish the construction on these two great buildings. We're very proud of the work we do, and we know you're proud of the hotels that we're building for you. And so we're going to see what we can do to rebuild some trust and move forward.
I very much appreciate that sentiment. I think rebuilding trust is of utmost importance to our client as well. To be perfectly frank, they were furious. They felt that there's a lack of trust. They don't understand how the liens could have sort of escaped the notice in the first place. And we had an opportunity to sit down with them, and what we hope to bring to the table is a more tempered approach to this negotiation, because as we all know, furiousness isn't going to solve the issue. And so we're hoping to extend an olive branch, so to speak. We feel our clients feel our reputation is at stake, and in addition to the concrete solutions that we generate at this table, we'll also need to bring some assurances back to our clients. So we're looking forward to generating some ideas.
Great.
And Bill at Progressive Hotels, who's kind of our main point person, is really looking at this as a partnership. It's a collaboration. Obviously, the buildings are being built for Progressive Hotels, but at the end of the day, a hotel doesn't get built without a quality contractor, and we're looking for that performance from Wilco, and we're pretty sure we're going to get it. So.
Well, and as I said when we started, there was some comfortability with both sides. Obviously, we understand what you do. You know that Wilco is a high quality construction firm, and so I'd like to start out first of all. We're aware that the liens obviously caused a concern for us too. Mm-hmm. We were also a bit furious on some of it because we were surprised as anybody. Mm-hmm. And we've gone ahead and made an instant move that will take 4 of those liens off the table.
Oh,
okay.
That's good to hear.
Could you maybe
I can tell you, it's the dirt and gravel.
Okay.
The dirt for the Paris, which was $20,400, and $19,250
For a total of
for
50?
Brown.
Okay.
Okay.
That bill has been paid. The liens will be released immediately.
Okay.
And I'm sorry, to clarify, there's a number of liens on the Brownville property. Which ones specifically have been taken care of?
The dirt for both of them, for
Okay.
both Paris and Brownsville, has been taken care of.
Mm-hmm.
The gravel, which was $30,900 for the Paris and $31,500 for Brownville,
Yep.
have also been taken care of,
Mm-hmm.
Wow.
and those will be released. So when we sit down and take a look at it, I think when you're looking at Paris, we're going to be at the 50% mark within 2 weeks,
Wow,
Okay.
that's really great to hear.
which is the goal that we had.
Mm-hmm.
The lien itself are in the process of being released, so that won't be a problem. And we will finish construction on that on time.
That's great.
So really the concern is limited to the Brownville facility and the other issues there, because the Paris is going to be finished on time. We're happy with the quality. We're happy with what's going on there. It was a bit of a chagrin on everybody's part. We were all a little angry, but the good news is it's gone away, and now there's no more problem.
Sure.
And we've limited our concern to the Brownville property.
Brian, that's really great to hear. Those were obviously concerns, and I'm glad they're taken care of. And that it sounds like, is it Paris Springs is the one
Yes.
that's on time? That's really great. The Pattersons are going to be really excited to hear that.
It's nice to know that it's half the problem they thought it was when we first started,
Yeah.
and we're finding a way to make it go forward.
With all that being said, I think that we would still like to hear a little bit how those liens came about in the first place.
There was a miscommunication between the vendor and us. We were unaware. We were not notified they were going to put a lien on. And the lien was put on much to our surprise, to be very honest. We took a look at it. They had a valid bill. We went ahead and paid it as soon as we knew they had a valid bill and moved forward.
And
Okay.
do you know the nature of the miscommunication?
You know, it was between us and Brownsville, or between us and the two vendors. And I honestly, we could run down exactly, give you names and numbers, but our concern was more, we can repair this problem immediately. How do we move forward with the Brownsville problem? And what does it take from your end for us to be able to rebuild the trust with Progressive? Because we'd like to know, what can my client do to help rebuild that trust with
Right.
Progressive?
Yeah, and Brian, we appreciate that, and likewise, we would be. It's in everybody's interest that that trust is there. Like we said, you know, these jobs never go exactly as planned. There are always little hiccups along the road, and the better relationship we have, the better we can deal with them. With all that being said, I think that to make sure that this doesn't happen in the future, and not to say that it will or it's inevitable, specifically with the liens, are there specific steps that Wilco is prepared to take or have planned in order to prevent this type of miscommunication you were speaking of?
You know, anytime there's a surprise lien, which this was a surprise lien, I don't know that we could take specific tasks or specific steps without knowing what would Progressive like to see. You know, Progressive, what do your partners want to see so that they're confident on this one, so that they can move forward, we can rebuild this?
That's a great question. I think transparency. And so I think they're going to want to enter into a period where there's a lot of communication. As I'm sure you know, Bill has been primarily hands-off in the first 5 months of this construction. He's been out to visit the properties twice. We're going to want to tighten up that chain of communication. And so more, you know, whatever sort of methods we decide for them to be in communication, we are going to want communication perhaps for a short period of time. We'll want to see progress updates accompanied by receipts so that we know things are getting paid timely. And as that trust rebuilds, of course, they're willing to sort of step back and let you do what it is that you do best, or rather, the Wilco.
You say you're looking at having more communication, and I think that's absolutely the solution. I think that's a great idea. That's absolutely a solution to the problem. It is more communication, more frequent communication, and maybe even better communication. And so when you say you're looking at some meetings or reports, if I can go back to my client and say, okay, here's what the new process should look like.
Right.
What would that new process look like for Progressive? Is there a time frame they want meetings? Do they want them weekly?
Yeah,
You know, what does that look like?
I think weekly meetings, at least in the first, let's say, the next 3 months of this relationship.
Right.
Weekly meetings, and we're going to be looking for an accounting of the work completed, the cost of the work completed, and then outlays that have been made by Wilco in satisfaction of those that completed work.
Well, and I've got a proposal then. Is there anything else we need to add to that, or is that what's on the list to help them
I think
rebuild
that
this
as
trust?
far as you know, that transparency and the trust that we're talking about, those items would certainly be a great step in the right direction.
Okay, I want to make sure I understood. So let me make a proposal on exacting. We can sit down and say that obviously the secretaries of all the parties have to figure out what day works during the week, but we'll have a weekly meeting, but let's do it on site.
Okay.
Because if there's questions, the on-site meeting can ask, why are you doing this? Or why is this happening? Or what's going on with this? I think the on-site meeting is important. As for the accountability of the work, we have many times used a form that makes sense, which is an overview form on the front, which is simply a listing of, it's like a control sheet that we can put up, which will give you, for this 1 week period, here was the bills we received, here's what was paid. and deliver that at the meeting itself, so that we can physically put it in his hands if that's what you're looking for. If you're looking for anything beyond that, I will tell you that it is readily available. If you say, we have a couple of concerns about these bills, we're more than willing to give you the backup that's involved with that, the actual billing statement itself. I don't know if you want to deal with a ton of paper or just a control sheet that's an overview. Does the control sheet help solve the concerns, or do you want to physically see the invoices and the checks that back it up?
Could you just, again, itemize the contents of that control sheet?
Well, the control sheet would say date we received a bill, the bill name, what the bill was for, the date we paid it.
Okay. And so presumably that would give a good indication of the work that's been completed based on what's coming in.
But the problem is, it doesn't really tell you the work that's completed in the construction company. All it tells you is what we've been billed for.
Okay.
There's some materials that we bill the day it shows up, and concrete is one of them that we'll end up getting in for. We get billed the day it's there. It's not paid till after it's delivered, so there's a lag time.
Okay.
So in the construction industry, labor bills are paid after the labor's performed. So sometimes it's work that's about to happen, sometimes it's work that has just happened. But the percentage of work, as we know, because the payment due on the 50% mark is tracked as a percentage of overall, but each week there will be a mixture of things that are coming up or about to be delivered and things that have been delivered. So it's really not an accounting in any shape of exactly what work was performed this week.
Okay.
And I assume, though, that this control sheet, it sounds like it won't give a complete picture, but it gives a pretty good indicator of all the sort of moving parts. I assume, as you said, if Bill or who's ever there in his place has any questions, that's something that then on site they could go through together and find the answers to any questions that they might have.
They probably couldn't find it on site because the financial records are kept back at the office.
Okay.
But if Bill said, listen, I have some questions on these things,
Right.
Obviously the construction foreman can tell them what they were for and how that tied into the project. But we'd like to be able to then go back and get the copies of whatever we need to deliver. We're not going to drag a copy of our entire books to the work site. That's just unmanageable. I mean, if you're more interested along the way, we could do weekly sites at the work site, and then once a month have it in our office where we do have all the financial records available in case there's any questions. I mean, I don't know if that helps satisfy it more, and I would ask if that's more what you're looking for, or are you looking for the site visits?
Well, I think that the site visits are great, obviously, because there's the actual, we can actually see the progress, and I think that for our clients that, there's something really satisfying about that. And there's no fudging that can happen that tower didn't go up. The one thing that we're going to need to really satisfy and is how to make sure that we can keep track of the level of work completed. And one idea that maybe we can do is Wilco would prepare, considering that this contract's benchmarks are based on percentages. If Wilco could prepare a percentage, so from week to week we say, last week it was at 60%, this week we're at 63.5%.
We could take a look at that, and I want to take a look at how we satisfy your need. And I hear that you're saying you'd like to know, instead of just every 6 months or when we hit 50% or the end, you'd like to see more of a progress. Is that what we're looking for?
Right.
Is that what
We'd
your
like
client's
to
looking
see
for?
the level of progress.
It's tough to do on a week-by-week basis, because do you consider, it's like pouring concrete, and I'll use that as an example. We pour the concrete's in the ground, but it's not finished. Okay, is that like 0.5% or is it 0.6%?
Okay.
What would be easier is if we had a monthly update on where we are, because in the construction business, things will slide early and late. Sometimes we get good weather, things progress more quickly, and then you can hit a doldrum when it rains.
Okay.
It's tough to pour concrete in the rain. So what I'd like to do, if you're okay with this, is to say we'll do the weekly meetings. Did you have an interest in doing the monthly meetings in the office, or just the weekly meetings on site?
I think the weekly meetings, and
Right.
then as you kind of had mentioned, if there were specific items that maybe seem foreign to whoever we send to do this audit, they could specifically identify that, hey, can you produce this document, and explain the documents that support those numbers on the cover sheet, or the cover sheet. And then maybe at a monthly interval, we can have that progress percentage.
Okay, and monthly would make better sense. So we're looking at the weekly meetings. We obviously will, if there's any questions, we'll produce it. And what we'd like to do is we're willing to send our accounting people to your office with that backup.
Okay.
If it gets fairly voluminous, we're gonna ask that you come our way because we don't wanna send a pickup truck full of papers across the town.
Understood.
And then monthly, we'll give you an update on what the completion percentage is.
Completion percentage.
Okay?
Well, it sounds to me like we have a good plan for the Paris Springs Hotel. We're having these weekly check-in meetings. The liens are resolved. I'd like to turn our attention to the Brownville property, as it seems that's the one that there's more concern about. And specifically, Bill was out there viewing the Brownville site, and he had seen some, was it damage to the framing? There was some concerns that some work had not produced, with the, it didn't look good.
By the sounds of it, it sounds like somebody backed a truck up or.
Well, I can tell you that if you'll give me just a quick second, we're talking about these meetings on both properties, right?
That's correct.
On both locations, okay. I just wanted to make sure I had it, so
Okay.
Yes.
now. And I am glad you brought that up, because that's one of the concerns that came up with the liens. As we went through, there was 3 liens left on Brownsville that were left unsatisfied currently. One of them was a plumbing lien, and the dispute of that was because when we looked at the running feet of pipe that was used to move the gas line, it seemed like they may have been moving it through Oklahoma back our way because the cost was so much higher than it should have been. And because we're trying to keep all the expenses down and trying to limit change orders, we were in a dispute with plumbing and wanted an accounting from them on exactly what the material that was used.
Okay.
That's the
Okay.
$7,780 that is in dispute over the lien.
Okay.
Okay. And I guess I'm surprised we're hearing about this for the first time this far into the meeting. But it's good. So this seems to really be the issue that we need to find a way to resolve.
You're right, there's a couple. I wanted to take care of the ones that were easy to get rid of so we wouldn't get balled up and then start to spend some time on this.
Good. So
It's normally that if it's a dispute with a sub, our vendor is not gonna be the one that's gonna start the argument. We're paid to handle these. There is a dispute. It was an overcharge of $77.80. We think we can make that work within the budget, and so we're willing to pay that. We're willing to pay that out of our end on this and not put in a change order for it.
Okay.
We're willing to take care of the $77.80 for the plumbing.
okay. And what is the status? Is the Brownville location on schedule, or does this put us behind schedule?
That has to do with the concrete, which has to do with the damage. They all tie together. I'll tell you that right now, the framing damage that you're looking at is because of the roofer, which is one of the that's one of the liens that was put on. And the bill that was put on there was $26,300 worth of damage that was done with the roofer. We were trying to do a layoff between the expense to have the roofing versus the bill. We were in discussions with them. They understand that it was their employee that did it, and so we were talking to them about that. And we think we're going to come to an agreement on it.
Okay.
The problem we have is we can't move forward, obviously, if there's a lien there.
Right.
So we're in discussions with them right now, and we do not have an answer on that. The other lien has to do with concrete, that when it showed up, the cost of the concrete was a $63,000 bill. In reality, it showed up $28,000 over what the concrete company had estimated. And we were going to ask about putting in a change order for the $28,000 because it was pure materials. It wasn't anything, it was the time lag between the contract going out and the concrete going in the ground. So we were gonna ask for a change order for the $28,000.
And that's on the concrete?
On the concrete alone. The rest of it was.
$28,000.
Yeah, $28,000 flat is the change order we're gonna ask for on that.
Okay, let me ask you, with these subs that you're working with and you have some disputes which happen, what is your relationship with them?
we're still using them, but as with some disputes, they take a little longer than others to work out. This is the same roofing company that did the work on the Paris hotel that went so well. And so he'd already had a track record. The dispute is, the damage and how we're going to be able to get that paid by them. Are we going to do a set off on the bill?
And the whole 26, the whole value of the lien, the 26,300, is that the value of the damage?
That's the value of the damage, and that's what we had not paid them off their larger bill.
For the offset.
Right. And we were trying to get it offset. Now, whether that happens, the debate is still going on, but we're in the middle of that, fighting with that.
Okay.
I will say you asked about timing, and I want to make sure I answer that. The timing is we are looking at not being at the 50% rate for another 6 weeks instead of 2 weeks.
Okay.
So there is a 30-day delay to the finish of construction. We took a look at ways that we could limit that. We could speed up the construction. We don't think anybody does their best work when they're pressed to do it less time than it really takes to get it done. We're very aware that there was some initial conversations about having a staggered start of the two properties. We're just going to ask for a staggered finish of the two properties. We started them at the same time, but this delay, we're going to ask for a 1-month delay on the completion.
Okay.
It would, because our contract is tied in with a percentage of completion being 100 after we hit 50, we did want to let you know that the 50% completion bill would not come due for 6 weeks, and that the completion at this point looks like it's going to be 30 days late.
Okay.
And so we were going to ask for the extension on the time period, and if we could get a change order for the $28,000 for the concrete, where the goods showed up higher price than the initial estimate.
Has that $28,000 already been paid out in increased cost?
It has not yet, which is why the concrete company placed the bill on lien, which we were surprised at, to be very honest, because we hadn't had a chance to even bring it to anybody yet to see how we were going to get it paid.
Okay, and
The remainder of that bill is in the budget already. So the remainder of the $63,180 bill is in the budget. It's only the $28,000 overrun on the cost.
Understood. Brian, how is Wilco doing with the previous $4 million on the Brownville property? Is that going to get them to the 50%?
Oh, yeah, we're not looking for, except with the exception of the $28,000,
Okay.
everything else is going as it should. The expenses are right. Brownsville, that's why we're coming back for the change order. That happened in the first 50%. We're asking for an additional $28,000 as a change order in the first 50%.
And can I just clarify? Due to these delays, we're about 6 weeks, is that correct, behind schedule? But you're able to turn those 6 weeks into merely 30 days by the time the project is complete?
I probably didn't clarify it well enough. I'll try again. Sometimes that happens. I wander off. We were supposed to be 2 weeks away. We were at 5 we were supposed to be 2 weeks away from being at the mark, the completion mark. We're actually going to be 6 weeks away. So I said we'll be at the 50% in 6 weeks.
In 6 weeks,
right?
understood.
And that will be 4 weeks behind, and
Okay.
that is just going to translate through the second half of the contract.
Okay. So Brian, one thing I think it's important to keep in mind here, these liens, the existence of these liens prevent Progressive Hotels from accessing the $4 million worth of financing.
Per location.
Per location. So it sounds like Bear Springs is going to be all set. It's at 50%. That $4 million will come to Wilco, considering everything goes smoothly here. Brownville, however, as long as these liens are on Brownville, that $4 million isn't coming from the bank. And so I think we have to find a way to get those liens done, quieted as soon as possible, so that when Wilco reaches that 50% mark in 6 weeks, it sounds like, we can get them the $4 million to finish, either on time or with some extension.
I agree, because I think that the most important thing to both our companies is what the picture looks like at the ribbon cutting. And it'd be nice if everybody was smiling.
That's exactly right.
There's nothing worse than a picture of a ribbon cutting and you can tell who the contractor and the vendor is because they're staring at each other with shovels in their hands. I'd much prefer that everybody's grinning. So my question is, if we're coming down to the real two issues, because we're willing to pick up the plumbing,
Yeah, it sounds like that.
And actually, the three that we have on, one is the $28,000 change order
Mm-hmm.
for the concrete, the $26,300 in the framing damage, and the 1 month extension.
Okay, the 28,000, the 26,300
Mm-hmm.
are kind of the values that's kind of hanging up the liens, is that
Correct.
accurate? Okay, well, one idea that we have, considering that 28,000 is an increased cost of construction, our client has authorized us to put some value towards that. We could put some resources at extinguishing that $28,000 increased cost amount.
Mm-hmm.
And what we do is that and we could do the 26,300. So essentially, extinguish the liens.
Mhm.
We'd quiet the title of the property. That would trigger the $4 million once the 50% completion. And what we do is we'd say, if the property is completed on time at that 12-month mark, we would call that 26,300 good. So it would incentivize Wilco completing the property on time.
If you don't mind, what I'd like to do right now is take 5 minutes.
Sure, Brian.
And make sure I've got comfortable parameters for my client. Because what I don't want to do is to make a promise that's not going to be fulfilled and it's not going to work for both sides.
Certainly.
So if I can take 5 minutes to do that, and then
All right.
I'll be back.
Look forward to hearing from you.
Thank you for taking a moment to gather the correct information. And Franz and I were just stepping out in the hall and reflecting that really both of our primary interests is resolving and restoring the relationship. And you've come to the table really prepared to offer a lot. We weren't sure what kind of a meeting we were walking into, and so we really appreciate the flexibility and the quick agreement to things like the inspection. And so we're hoping we can get some of these last details hammered out.
You know, I think we can. I think that and I appreciate you guys coming to the table like this, and I understand the irritation of both your client and my client, and that we can try and get by this. I had a question. I needed a little more information before
Absolutely.
I can. When there was obviously a concern about completion date on the Brownville, whether
Yep.
we make the year.
Yeah.
What's the concern about the completion date on that? Is there something driving that?
Absolutely. We have perhaps at most 2 months of leeway into that year that that was agreed upon by both parties, and that 2 months is the maximum. Progressive hotels would be a whole lot more comfortable knowing that it will be a firm date of merely 1 month over. So as soon as we start getting into that last month until they need to have their doors open, they've booked some events, they've booked a grand opening. There are a lot of pieces in play and some money that has been put down. So we really need to just ensure that those doors are open and that blue ribbon ceremony with the smiling shovels happens at no later than 2 months.
Yeah, if you can imagine, this is going to be a business. We want to get revenue getting out of that building as soon as it goes up. We've made plans, our client has made plans right around that 12-month, more or less depending on that.
Right.
And again, we would have some flexibility, and going back to the offer that I had extended, the $28,000 of increased cost, we can add to the budget currently before the next $4 million distribution to the Brownville property. The $26,300, in the interest of quieting the title and being able to have that $4 million of liquidity upon 50% completion, we can pay that as you and Wilco resolve that dispute with that sub, regardless of the outcome of that discussion. If the Brownville property is finished at 12 months, we will say that $26,300 is good. And that's
Okay.
creating an incentive to get the hotel done on time.
I have to tell you and I appreciate you doing that, by the way. That's, in the industry, construction over 10 million runs 1.5 to 3% profit, so it's pretty tight when we get the concrete coming in over budget. When I sit down and take a look, I think that the concern that we have is if we rush the project through for the last 6 months, we basically do 7 months of work in 6 months. I don't think that you're gonna get the quality that you want or
Sure.
that we want. I think that we've both built our reputations doing good work. I think that we would like to look forward to a time when we finish this project where Progressive says, boy, these are great hotels and we want Wilco
Right.
to build our next hotels. I don't know that trying to compress that in, because there are, obviously, as we all know now, unforeseen incidents that can happen. I would be uncomfortable giving a guarantee that it's gonna be the 12 months.
Yeah.
Because we've already slowed it some, because the roofing, there's work
Sure.
going on with the hotels that's dependent on the framing for the roofing. So,
And
the
again-
1 month, and I realize we've got business, I'm glad you're booking business in there, by the way, they're gonna love the hotel when we're done with it. If we could look at that 1 month as a current extension, we're aware if there's anything that would be out of the norm or would press us where we think there's gonna be any further delays, and we
Okay.
realize that this is a very time-sensitive issue now. And thank you for letting us know that. What I would suggest is that with our monthly report that we give you, we can also let you know what our initial anticipated percentage of completion was. Because right now it was just 50% in 6 months, 100% in a year.
Okay,
Though it may shuffle a little bit, we can say we're at 67 to 69% in that range.
right,
And this is right where we think we'll be to finish by the 1 month extension.
understood.
That way, if there's anything that pops up, we know it right away and we know if we have to
Great.
deal with it. Do we have to throw some money at it? Do we have to throw some time at it?
Yep.
You know, what is it that's gonna go on? But we're willing to say, let's take a look at it that way. Let's sit down and say, you know, we'll go through this. We'll make sure you know exactly where we
Okay.
are in our anticipation of the 1 month.
Yeah, and Brian, I think that was our understanding of the monthly and weekly
Mhm.
meetings. What I may have miscommunicated
Mhm.
is that the incentive that we're creating by encouraging that the construction does get done in 12 months, we're willing to give leeway that extra month. We would hate for the project to get rushed, as you said.
Okay.
The incentive is if it does get done, the 26,300 is an extension of value that Progressive is willing to give to Wilco, essentially eat that amount that's in dispute. And, you know, if Wilco settles that favorably for themselves, that's a straight boon to them.
And I think certainly we don't want you to cram 7 months of building into 6 months. We understand that the standards of quality have to remain the same, that Wilco will not be satisfied building a building that's not to your quality. It reflects poorly on you and it reflects poorly on us. But merely that this additional month, which is granted but incentivized to finish at 12 months instead of 13, that allows Wilco to reap the reward if, for example, they've allocated so many days for window installation. However, window installation goes smoother and takes a fraction of those days. I don't have much experience with building commercial hotels, but I've done a little bit of home renovation projects, and I know as well as anything, some projects go much longer, and some projects can be completed in a quicker time, and so it's really up to your creative solutions how
Right.
those next 6 months can shape out.
And to play those scenarios out, Brian, at 12 months, the hotel is done, and you have, Wilco has settled that ceiling dispute favorably for themselves. They're gonna get a boon of 26,300.
So,
If it takes an additional month
Mhm.
and they've settled it favorably, then they've settled it favorably and all's even. If they don't settle it favorably, we have paid that off on behalf of them, on behalf of Wilco, and Wilco would just need to reimburse us for doing that for them.
Okay, so I want to make sure I'm really clear. If we are able to complete in the initial 12 months, that's where the incentive is on the
Correct.
26-3.
Correct. We will pay that dispute on
If
behalf.
it goes to 13 months with the month extension we're asking, then we would be liable back to Progressive.
You'd have to reimburse us that 26,300. And that can go one of two ways. Either you just settle that dispute with the ceiling sub favorably, and it's a simple transfer of funds. If you don't settle it favorably, then you just have to reimburse us.
Let me ask you a question. What if we just agreed that, because we really do need the extra month to get it done correctly. So for us to say we think we can get it done in 12, I would be being a little disingenuous and not representing correctly what we think the situation is. What if we just said we were going to subrogate the claim where if there's, you guys are willing to pay those 2 fees, and if there's any type of settlement, whatever the settlement is, it automatically goes back to Progressive.
I think we're speaking in different terms but saying the same thing.
The only difference is at the end of the 13-month period, if it takes us 13 months to complete, if there has been no payment from the roofing vendor, then we would not be liable for it. We would only transfer those funds to you if it was paid by the roofing vendor, so we can, subrogate the claim from you guys.
Okay, without knowing exactly the nature of that dispute, I think I would be a little hesitant to agree to something like that.
It was damaged by one of their employees.
Yeah. Maybe if we can stick with the incentive idea, and if it's done in 12 months, like I said, 26,300 will be paid by Progressive on behalf of Wilco to settle that.
Right.
And again, this all goes back to freeing up that $4 million
Right.
loan from the bank. If it's done within the 13 months, Progressive and Wilco will share that cost, and that'll be $13,150.
So it would be a split of the cost
Of the ceiling dispute,
of the ceiling dispute.
assuming that the ceiling dispute is not settled favorably.
However, if it is settled, what happens if it's settled?
If it's settled favorably, everybody's
We
made
just
whole.
we just made whole by it.
Right.
Okay. I think I can probably go back to my client and make that happen.
Okay, that's really great. So just to recap how those liens would be extinguished, we have the plumbing lien, which Wilco has agreed to take care of. That's the 7780.
Correct.
$7,780. What's the 63,180?
Well, we have the $28,000
Oh, increased.
increase.
Yeah, the concrete was actually the $28,000 change order.
Right.
Okay.
That was taking care of that. The 63, the remainder of that, we already have.
That's right.
We know that you're gonna take care of the framing damage, and if we utilize the 13th month that we're getting, we'll split the cost on that.
Yeah.
Right down the middle. However, obviously, if the funds come back from the insurance, we're all made whole
We're all
on the thing to
great.
begin with. So what that would actually mean is if it happens before the 13th month, we would just write you the check as a pass-through within 30 days after we receive the insurance check from them. Within 30 days, we
That
will make
sounds
sure.
right.
Yeah, because you would be on the hook for it until the end of the 13th month,
Right.
so we'll
I
do
mean,
that.
we've got to actually pay this.
Correct.
Within the next 2 weeks to trigger the $4 million.
And that's why we said we'll just, if it comes through within 30 days of receipt, we'll pass it through to us because we're the vendor. It would come to us. We'll pass it through to you within
Great.
30 days.
Great. So it sounds like we freed up Brownville, which will allow the $4 million loan from the bank in 2 weeks, in 6 weeks.
Correct.
At 50% completion.
And I'm very pleased. We've made some really good progress. Our clients, one of their final concerns in all of this is their reputation. And it's very important that subcontractors, that are not party to these disputes, they really want to make sure that the word of this doesn't get out to future general contractors that they might use. Could your client agree to a non-disclosure agreement for the nature of this meeting?
You must have been reading my mind, or you're reading my notes. I think a non-disclosure is great because it works both ways. Our reputation is also on the line.
Okay.
Exactly.
What we don't need is a potential future client saying, well, I heard you had problems with the Brownville property. you don't want it either. I think that a non-disclosure makes sense on both sides. I think that we go on forward with this. We will let you know if there's any further disputes also with any of our
Right.
our subcontractors in our weekly meetings. We'll make that as a standing point in our agenda, that if there's any contractor concerns, subcontractor concerns, you'll know that immediately.
Agreed.
And so we're gonna do the weekly meetings. We're gonna monthly meet at the accountant with the accountants.
Yep.
Costs and outlays on a monthly basis.
And then receipts and documents, supporting receipts and documents
Upon
upon
request.
request.
And,
That's great.
and additionally, the progress broken down by percentage.
Correct,
Yeah.
monthly
And a monthly.
and related to what the estimate was.
Okay.
Yep, and then to just hammer out the details of that non-disclosure, as we all know, something like that is about as worth as much about, what am I trying to say? Worth as much as the paper it's written on unless it's got some teeth. We were hoping to come up with a 200,000 liquidated damages. We don't anticipate anyone breaching that, but that I think will show a commitment from both sides that it won't be breached.
I don't have the authority to approve that right here. I can take
Okay.
that back to my client, and I can have him take a look at that, that's not a problem.
Okay.
And we'll set another meeting to deal with that.
Okay.
Okay, I think that's great. I think that if we can get a, maybe like an MOU on the non-disclosure, and then very quickly after today, maybe next week, same time, same place, come up with how we're going to make that an enforceable non-disclosure.
I think that I agree with that on the general non-disclosure.
Yeah.
As far as any penalties, we're gonna have to sit down and work those out
Yeah.
at our next meeting.
Yeah.
Our clients will be pleased that it's felt that the non-disclosure is in both of their interests, and so we can set a time and finalize the details of that.
We look forward to it all, and we look forward to going forward, and we can't wait for the ribbon cutting with
Yeah.
everybody smiling.
Yeah,
Yeah.
let's just humor me one more time with a recap on the Brownville lien situation, just so, because there are a lot of
Great.
moving parts there.
Go
We're
ahead.
talking about Wilco taking care of the plumbing lien
Correct?
of $77,780. Progressive will transfer Wilco $28,000 of the increased supplies cost on
Correct.
the concrete supply contract. And the remaining $63,180 will be paid off by Wilco. And this is all within the next 6 weeks before the 50% completion mark.
And actually, since both of those are coming from us, the plumbing and the concrete, if you'd like, we can send you copies of the checks once they're
Yeah,
canceled, so that you're comfortable. That way, when you transfer us the 28, you'll know that it went to the appropriate place.
And I think the bank's gonna wanna see that.
I'm sure they will.
Yeah.
And on the framing damage, since that's coming directly from you, if you could return the favor and make sure that we're aware
Yeah,
of that, so
that's
then
great.
we can move forward with our roofers.
And then we potentially, all of us can collaborate on just keeping tabs on that litigation or that dispute resolution with the ceiling contractor, just so we know what that 26,300 is. Where that's gonna
Absolutely,
come
and
from.
the nickel on that, since we're already in the middle of that, we'll just keep you informed, because we're the ones that are already in the middle of it. That's at our expense, we'll take care of that.
Great. So we'll take care of going back and drafting up this agreement, and we'll send it over to you. We have your email on file. Is that the most appropriate?
It is, it's the
Okay.
easiest way to find me.
Wonderful. And then we'll schedule a time shortly thereafter to hammer out the final details of the non-disclosure.
Great,
You got anything planned for the rest of the day?
not much.
No?
Not
All
much.
right.
Good.
Likewise.
Thank you.
Well, thank you for meeting with us.
I look forward to it, and I'm glad our clients are gonna get
Brian,
this hotel.
good meeting with you. Good meeting you.
Nice to meet you. Thanks.
Myself and Alice, first of all, it's obvious that I'm not the traditional law student. I have a little more life experience. And one of my strategies, and I do want to talk about strategies, what I do the same and what I do different. One of my strategies was try to utilize some of that experience to make sure I didn't fall into a trap, that I didn't end up doing something that was bad for my client. When my partner took ill, it changed some of my strategy, because I had a style strategy to slow down a little bit, because I had to memorialize also. There wasn't two of us working the problem, but only one. And in looking forward at this, I thought my concept was, I wanted to be a very settling force because this could become volatile quickly. I felt that if it became a contest and a competition of beating heads, that I was here to try and start rebuilding trust because that was in my client's best interest. When I had the chart on the must-haves, there wasn't that many must-haves for my client. My client thought he was going to have to pay for the entire $26,000 for the roofing, and I was comfortable that the strategy was to try and see if we could get some of that taken care of, which we did, at least half of it or all of it. We got the change order we wanted, and we got the other month. The strategy I took with taking the 5 minutes was I wanted to review the paperwork and make sure on that 13th month if it was something that was possible to do. And it didn't ever say it had to, it said, but it probably was going to take it. And I would have been uncomfortable committing my client to saying, oh, God, just cut a month off your construction time. I don't think that would be protecting him from his best, what is best for him or her. Things I would do differently, I think that initially, if I had drilled down a little more to see if there was other interest involved or other ways to rebuild the trust. Because trust is the big word I wrote on top of my paper when I first read this. They obviously had a trust issue. They were surprised by liens, so were we. But I didn't want to go so far to build that trust as to expose my client to possible liability, which is why I chose my words carefully when talking about what happened with the bills that weren't paid. Because I didn't want to say, oh, it's our fault, we screwed it up. Because I did not want to expose our client to a potential liability issue, which doesn't mean I've felt like I've totally protected him, but I wasn't going to make an admission in a negotiation session that happened. I think I should have, I think I would have seen if that non-compete was there at the beginning or if it was an add-on at the end. It was a good idea, and we'd written it down as a possible, I mean, the non-disclosure I meant, I'm sorry, I misspoke. A non-disclosure. I think the non-disclosure was in both interests, and it was a concept that I'd considered going forward. I didn't think it was going to be horribly important. I thought the other issues were more important, so I'm glad it came up at the end. If I drilled down a little bit more on their initial, what do you see as trust looking like for you? I think we might have been able to get that out earlier. What I would do the same, their response on we need paperwork, we need accountability, we need transparency, was a combination of experience in businesses that need transparency and trying to fulfill their needs. And so I would, if I was going to do it over, I would again hear their full issue on this, on what they needed with the transparency, and then try to build the custom-made modifications to satisfy their interests, which is why I did drill down again, and I'm glad I did, saying, is there anything else you need, or is the trust issue now, or is the transparency issue done? So I was comfortable with that. Overall, I think that I'm comfortable taking this deal back to my client to say, here's what we got. We got the change order you wanted. We got the month extension you wanted, and I may have gotten half of the roofing paid for, which you thought you were going to have to pay for. A final strategy that I had was, we knew we'd paid these bills up front. We knew we had already gotten that off the books, and I wanted to give it to them right away, right up front. Say, if we're going to talk about trust, I'm going to show you trust. We paid these bills. It was a miscommunications. And then stonewall it there where it didn't go any further, and try to very honestly divert to the other issues and say, well, that's great, it was a miscommunication, on we go. It was a strategy from the beginning, and it played out the way I thought it would play out. So that, I was comfortable with that. I was also comfortable with the verbiage I used. I wanted to be careful to not use anything incendiary or, you have to understand the construction business. No, they don't. That's why they hired me, or my client. So overall, I was comfortable, and I'm comfortable taking the deal that we got back to my client and saying, we've fulfilled your needs. On the right-hand side of my sheet, I always have a little thing that I put, why, which is, why does my client want that? What's his real goal? You say, oh, I want an extension. Well, profits aren't narrow. So Why does he want that? Well, he's also worried about his reputation. Okay, so reputation isn't in the fact pattern, but that's really what he's worried about, is his reputation and the potential of future work with these people. So I was comfortable with the strategy. I would drill for a little more information, but I think overall I'm comfortable with the deal that I got for my client.
Well, I think you certainly carried through on what you did, I think excellently in the beginning, that you sort of gave away. You pulled the rug out from under while trying to rebuild trust. The one thing that you knew your client was wrong on, you gave on immediately. It sort of surprised them, but you also never really answered the question of why did it happen in the first place. So I thought you really carried through on that strategy very well. The one thing that I was left with a question is I came away with a very strong feeling that you needed the extra month period. And I didn't think they were hearing you, and I wasn't sure at the end of the negotiation whether you had a commitment that they would let you have that extra month. They kept talking about incentivizing. You didn't need an incentive, you needed the extra month. And I don't know, I'm lost, I'm left wondering whether you two really ever connected on that, but you did try.
I will tell you, you got off lucky. They didn't ask you for proof of the liens, and I would have, if I were them. So, as a suggestion, you should have offered proof that the liens had been paid. You know, they let you get away with that. The other thing is you threw in facts that were not in evidence. You threw in the profit margin in the business, suicide mission. Because if they had been aware of what was going on, they would have said, fine, lay it all out for me. Show me where your labor costs are. The billing procedures were not in evidence, nor were the labor. You quoted both of those as saying, you know, our labor and building procedures, but they were not in the fact pattern. So one of our criteria was, did you stick with what the fact pattern was? Now, in a real negotiation, perhaps you would have done that, but it's very dangerous to throw in a profit margin for your client, because now you're giving away the store. Now he is exposed. So you have to be very careful about that, because if you're offering transparency, that's the next step. Okay, now we want to know you're making too much money, or you're not making enough money. And I'm sorry to go on this, but it's part of the criteria that, you know, as to whether or not you stuck with the fact pattern. I thought you handled it very well. The one thing I thought was missing was, based on the way I read the facts, is your client desperately needs the money. And to offer money that you don't know unless your client had told you he has, which is even the 13,000 some odd, if he gave you authority, fine, then he's got it. If you didn't have it, I'm not so sure where you are on that. Also, the last thing is confidentiality. Why? There's not a lawsuit here. Nobody knows what the agreement are. It's still contractual privity between the parties. Nobody's asked, no third parties asked for anything. So that seems a little superfluous to me. It was a nice touch at the end, but it was A, not in the facts, and B, I don't see the necessity for it.
But he didn't offer it, they asked for it.
Well, whatever.
So what's he gonna say? He can't say no.
Are we allowed to answer at all?
Sure, of course you
Okay.
can.
I was gonna say, the answer on the payment summer before or summer after was because when they said, we wanna know what you paid this week for work that's been done, and they're two different issues. Well, the work that's been done and what I paid this week are disjointed issues. And I wanted to make sure I let them know these are disjointed issues. And so honestly, that's why I said, you know, you don't pay payroll before people work. You don't, pay for concrete 2 months before it shows up. So if they were trying to equate what we paid with the percentage of completion, it was going to be an erroneous number. And I didn't want to get trapped into representing, oh, we've paid X amount of dollars out, so this is where we are on completion of the project. I wanted to make sure they had a stronger number to tie to, so my client couldn't get held responsible for, well, you paid 60%, we thought you were 60% done. Two
Do I
different
know
issues.
why?
Hi, I'm Franz Anderson.
And I'm Kiersey Luther, and we were counsel for Bill at Progressive Hotels. And in analyzing the situation, Bill came to us and said, that his hands were tied. He was between a rock and a hard place. He couldn't complete the project without the loans from the bank. He couldn't get the loans from the bank unless the liens were taken off the property. And he had no idea what resources Wilco had to take care of these liens. He was surprised about the nature of the liens in the first place. And so he really came to us and said, his alternatives weren't good, and we were in a tough spot. So that's the meeting that we came to deal with today.
Right now, we have a couple items that we'd like to discuss with you regarding the negotiation. First, we'll talk about the alternatives that we felt our client had to reaching any kind of agreement today. We have some goals that we'll share with you that we wanted to achieve on behalf of our client, some strategies we had to achieve those goals. We'll discuss things that we felt as though we went particularly well during the round for us, and then alternatively things that, given the opportunity, we would have done differently. Finally, we'll recap some of the outcomes and how those serve our clients' interests.
So our best alternative to a negotiated agreement was that Progressive pay the liens on the Paris Springs property. Those were the smaller amount that would allow them to get the $4 million from the bank that could then be used to pay off the additional liens on the Brownville location, which would put them about $200,000 in the hole with no certainty of where that, where that was going to come from. And this wouldn't serve their interests of restoring the relationship. If we couldn't reach an agreement today, there's no certainty for the future of the building and ensuring its smooth success.
Our worst alternative was pretty similar. We would attempt to quiet the title with the short amount of liquidity that the Progressive hotels had, risk jeopardizing our reputation and our relationship with the general contractor and the general contractor community, and potentially simultaneously needing a new general contractor.
So our first goal to serve our interests was to deal with the people problem first and then deal with the problem. As we know, disputes lay so much in perception. And so what we wanted to do was really preserve our reputation in the community. Our client understands that banks come and go, general contractors come and go, but if your reputation is damaged, it really inhibits your ability to get those future contracts that you need to ensure your business success. And so we wanted to do this by getting agreement on a non-disclosure agreement that would allow the privacy of this matter to be kept within the parties involved, and they felt that that served their interests of maintaining their good standing reputation in the community.
We also wanted to repair the relationship with Wilco, and to do that we needed to separate Wilco from the problem that faced the two parties, and we really wanted to focus on the principles behind the interests as opposed to the positions that we came in here with, and that allowed us to kind of avoid the blame game, which wouldn't have aided any kind of agreement today. Our second goal is to, again, secure an expedited construction of this building. There were opportunities for mutual gain, and we really wanted to highlight those. For example, the longer these liens were on the building, the longer that $4 million was tied, that $4 million loan was tied up at the bank. So we really wanted to demonstrate that and sell resolution in that fashion.
To serve this goal, we also wanted to come up with creative solutions like incentivizing maintaining the constructive schedule. This was, Brian felt that this was not going to be possible for the client, but that said, it may be possible. There's $13,000 at play here as a bonus if the dispute is resolved favorably, and it seems like there should be reason for it to be so. This really, perhaps Brian's client will feel differently, may feel that with $13,000 on the line, it's worth having an additional construction crew to work some evenings and keep that building on progress.
I think one thing that went really well for us was having Kiersey and I had really analyzed and developed our alternatives. That being said, there were very few, which really emphasized the need for us to come in here and reach an agreement. And within the table, within the discussion, it encouraged us to have a lot of flexibility on some of our positions, knowing that if we left the table without an agreement, the alternatives were not that great.
We wanted to provide a stake in the solution for Brian by participating in the process. If one party comes to the table and has all of the creative ideas, the other party can feel like, well, are these ideas really serving my interests as well? So we did this by highlighting what our client needed, which was assurances. And it was Brian that came to the table with saying, well, how about having an inspection? How about a weekly meeting? How about reporting? These were really in our client's interests, and by him presenting that solution, it paved the way to the success of both parties.
And then once he actually came up with those solutions, I think we were served really well. When they were kind of complex, there was a lot of construction jargon. Having him say, hey, Brian, frame these in terms that serve my client's interests. We've told you what our client needs. Please tell us why this cover sheet gives our client the needed transparency to know that you're going to be accountable.
That said, there are always things that you would do differently. One of the things that we would do differently is set an agenda. We needed to structure the conversation so that we could properly allow time. We didn't get to the non-disclosure agreement towards the end of the conversation, and had we known about that and been tracking the conversation along the way, we could have come to a finalized agreement on that term too, possibly.
I think that, as we discussed, the alternatives to reaching an agreement today were so bad, it would have been, the conversation would have been well served to discuss those, to bring them up and say, hey, have you considered what it would look like if we don't leave this table today with an alternative? And I think that having that be out on the table and everybody knows, it really would have possibly gotten even better results.
We needed to be more persistent in asking T-funneling questions about the nature of the disputes. We asked, and we were given somewhat of a vague answer that these stemmed from misunderstandings. We needed to find out exactly what those misunderstandings were and drill down on the factual circumstances, because when it came to light 20 minutes later, that was information that we needed right then in the moment. And so I think having that answer soon would have built that trust between us and Brian to allow us to know, okay, we're on the right track and we're talking about the right issues.
Yeah, I think along those lines, I think despite all the assurances, we could have gotten more with respect specifically to liens, possibly some sort of indemnification or some sort of action that would have been triggered if these type of liens were placed again on our property, our client's property, and specific protections from this type of action that we're trying to prevent. Some of the accountability and transparency items that we got will certainly help us have the heads up that something might be coming, but creating some sort of action or liquidated damage would have been really great. With all that being said, I think our outcomes were doing really well, did really well and served our clients' interests. For example, we are going to be able to trigger the $4 million of loan on time when the construction is 50% complete. We're going to get those, you know, the relationship between the two parties is, I think, what's really important here. I think that we've repaired it. We've developed a relationship with Brian. We're going to be working with him. We're going to have a window into the company and how it's run. We'll be working closely with our clients, making sure that Wilco is doing things that they should be doing with the money. With all that being said, I really look forward to seeing these buildings built and bringing this agreement back to our client. If you have any questions, I'd love to answer them at this time.
Probably time for one quick question. Go ahead.
No, please. You have a question?
No, I have just some comments, but I should wait until
Yeah,
both.
Well, either way, you can ask
Yeah,
one.
my quick question is, why did you start off with saying my clients are furious?
Why did we?
Yes.
That was the first line of our fact pattern, is that they were furious, and we wanted to demonstrate their emotion. We didn't want to use their emotion. We didn't want to come in here yelling and screaming. That's not why you hire an attorney. But we thought it was important that they knew the gravity of the situation, and we thought that the relationship again was the important part. And if they knew that our client was furious, they would come with some serious offers to repair that.
I don't think there's anything wrong with that. Your client has every reason to be furious. Not sure that you didn't let him skate away from giving you an explanation as to why these liens occurred. Frankly, I'm surprised about the non-disclosure. There's nothing your client has done wrong or needs to be embarrassed about. They're really the victim in this situation entirely. So that sort of surprised me. I thought, you know, do they get taught in law school that you have to have a non-disclosure agreement no matter
I
what
agree
the
with her completely.
situation is?
Okay.
Then there's one.
Let me start. Well, first of all, this is very difficult to pick up a problem, with very short notice. But if you ever become inside counsel, that's exactly what you'll have. So this is very good practice. And I think both of you did a very good job. I mean, you were smooth and persistent. And the most important thing in negotiation with goals is to be persistent. Both of you were persistent in pursuing your client's desire, but with sufficient amount of flexibility to recognize that the other side has some flexibility. That's very important to recognize that. You recognize the fact that if somebody walks out of a negotiation feeling, you know what, we got screwed, it isn't gonna happen on the ground. The agreement will never be observed. Somebody's gonna try to get around it, okay? The other thing is, when you get more experience, it's just completely related to the facts. Banks are more important to hold on to than contractors. Contractors are a dime a dozen. Banks are hard to come by because they have the money. But all in all, I think both of you did a really very, very credible job.
The only thing I was sort of curious about, I had the impression that you really needed the month extra time. Did you hear that? Did you pick up on the fact that they just were not going to get it done under 13 months? And if so, I'm not sure that I was able to follow what the agreement was on that. You seem to be very stuck on, if we incentivize it, they'll get it done on 12 months. And I really heard, you can incentivize it all you want, we can't do it in 12 months. Did I miss something? Did you hear each other on that?
I think that we had expressed that we had 2 months of flexibility. We heard that it was going to take 13 months. Despite that, we did want to create an incentive, not necessarily that goal would be reached, but that it would be aspired to. And that was kind of the idea with the incentive.
Did you feel that they did understand that it just was not going to happen in 13 months? Did you get the extra month?
Yes, and along with the extra month, I only had to pay back half of the repairs that were going to have to be done in the building, which was an extra for my client. I knew that they wanted to incentivize the 12 months. They could have put $1 million incentive. We needed the 13th
Right.
month. I got there, okay, all right, we'll give you the 13th month and we still get half that money back instead of all of it, or all of it if it comes through. So, yeah, I knew I got the 13th month.
Okay.
Substantively, I thought both teams were done very, very well, and I agree with what has been said. In light of the time, I'll go really quickly to something that I observed, which was manner and style. I thought you were yielding from the very beginning and encouraged things that way. And I thought you were yielding. Now, since my colleague on the right was sort of tough on you, I'm going to be tough on him. I thought you substantively were quite good, but I was concerned about the manner and style. I didn't know if you had good person, bad person there, and I think you could have been a little less caustic, not in what you said, but manner, speech, and I got the impression, and you certainly didn't cower him. Now, none of this is meant to say you did badly. I'm just saying it's something to consider and work on as you move through.
Thank you.
Okay?
30 seconds more. Most important thing in negotiations, you listen to what the other side's saying.
Yes.
He gave you big opening. He said, my profit margin is X. My billing procedures are there. That's the opening. If you want transparency, show me everything. Show me your profit margin, everything. Listen very carefully to what the other side is saying, because they may give you a lot more than what you know.
Okay.
And why did you not follow up right away when he said, we've taken care of these 4 liens? At some point you said, why were they there anyway? If you're gonna rebuild trust, don't you really wanna know? These 4 liens got there and now they're off and you never did find out why they were placed on the building, what proof there was that they were taken off.
There it is. What proof were they taken off? You accepted his word right away. Didn't ask for him. Okay, fine, great. Show me the release.
I mean, I think that's a great point. And I think we needed to have asked more of those T-funneling questions.
I mean,
as well.
because 4 out of the 7 liens were because they did not pay their bills. I'd be pretty upset as the owner to know that about my contractor.
Yeah.
Okay, I think we've got to close out, but thank you. You really did a very good
Thank
job,
you.
both of you.
Thank you so much.
That's very nice.
Hi, Danielle Lauber on behalf of Wilco. Josephine Kim, nice
Nice to meet you, Josephine.
Hi.
Josephine
Nick
Kim.
Hanna.
Danielle Lauber, nice to meet you, Nick.
Anton Swangill.
Nick Hanna, nice to meet you.
Nice to meet you, Nick.
Thank you both so much for sitting down with us today. How's your day going so far? Good, how are you? Excellent.
Danielle, we appreciate you guys sitting with us. Thank you very much for the warm welcome. And of course, we're here on behalf of Progressive. I'd like to think that the issue before us today is about the two building contracts that we're both probably familiar with at this point. We do have a lot of information to discuss, but I'd just like to set the tone kind of at the outset before we rush off into anything. We're here separate and apart from our clients, and we want to make that note only because, yes, our clients have very serious concerns that we'd like to address, and yes, they're not quite happy with where things are now. Having said that, we are two professionals at this table. I believe you two are professionals at this table, and we'd like to work with you and express, as much information as we possibly can to kind of elucidate any information you might need. We expect that in return. I think we can form a pretty awesome agreement and kind of make this problem go away.
That's great to hear, Nick.
Yeah, absolutely. And in terms of moving forward, because there are some complicated numbers and issues that we have to discuss, we're certainly going to be as transparent as possible so that we can reach something that's fair for everybody.
Great.
So
We're happy
we
to
certainly
hear that.
share that goal.
And we appreciate your willingness to be transparent in terms of information, and we think that's a great way to start this conversation. We're aware that your client probably has many questions about
We do.
the
Definitely.
state of the liens, and we think that's a great place to start to just make sure we're on the same page. So as I'm sure you're aware, there are currently 5 liens on the Brownville property. That includes a dirt work lien for $19,250, a gravel work lien for $31,500, a plumbing lien for $7,780, a concrete lien for $63,180, a roofing lien for $26,300.
Quite a few liens.
There are, and in regards to the Paris Spring property, there are currently 2 liens, a dirt work lien for $20,400 and a gravel lien for $30,900.
So there are 7 liens, correct?
There are 7 liens, 5 on the Brownville and 2 on the Paris Springs. And we understand that a lien amount of $199,310 was probably shocking to your client, and we think that in light of sharing information, we'd love to share that our client has already resolved 4 of those liens.
That is good information. Thank you.
So the dirt work liens on both properties and the gravel work liens on both properties have been resolved, checks have been sent, and those liens should be removed in the next few days. So our client is happy to share that in hopes that that will set the tone for having a productive conversation.
Well, that's a
today.
great way to start, and not a good foot to end this, or start this negotiation on. And that's roughly, I think, $100,000 of the $199,000 that
Correct.
was outstanding.
Correct.
Correct.
Great.
So
And-
can you tell us more about the current status on the remaining 3 liens?
Absolutely. So the remaining liens in regards to the plumbing, the concrete, and the roofing. So with the plumbing, there was an issue with our contractor for the $7,780. The contractor, we think our client thinks double billed us, and they haven't been able to send us a itemized invoice, and so we've been pressing them for that. And that is that's the plumbing line. So they rerouted a gas line that was already existent on the property,
Right.
and so obviously we're hesitant to pay them for double work, especially considering that the line may have already been there.
Sure.
In terms of the concrete, the lien currently is at $63,100.
Anton, I
Yeah,
don't
sure.
mean to interrupt you.
No,
I just
please.
want to just make sure we hash out everything about each subcontractor individually.
Yeah.
So when can we expect to hear back from this subcontractor? Does your client have any idea?
So we're going to have to discuss that. We don't have any specific information as to if there's progress being made. As I said, they haven't sent us that itemized receipt, and it seems like they're not willing to at this point. So
Do you have
we'll,
any information on when it was requested, this itemized receipt?
when the itemized receipt, I do not know that off the top of my head.
Our
but-
client hasn't expressly stated when he requested it, but he's made multiple requests, and just to echo what Anton was saying, it doesn't seem as though the subcontractor is willing to provide that itemized receipt. I'm sure your clients know, working in the construction business, these sorts of disputes happen sometimes, and
Of course.
it's just par for the course.
Absolutely.
And I think as a gesture of good faith, we've come to this table with a lot of creative ideas that could potentially help resolve these issues.
Okay, great.
That especially stretch beyond monetary, so I'd like to bring those up at a later time when we've actually discussed maybe the rest
Certainly,
of these
certainly.
subcontractors.
We'd love to hear that. And in terms of the concrete, so that's the largest of the liens. That's the $63,180 lien.
Correct.
So in that regard, there was a overrun in costs and materials. And so as you know, with construction projects, there can tend to be overruns, and this one was actually a legitimate overrun. So the only monies that actually need to be come up with there are the $28,000, and we have just waited to pay them because we wanted to give them the entire bill in full.
So, Anton, when you say overrun, can we just quickly define that? What does that mean?
Absolutely. So the overrun was due to unexpected material and labor costs, and that was just because in pouring the foundation, we had miscalculated what exactly that was going to cost.
Okay.
And this was just part and parcel. And again, this is $28,000 of $8 million of construction that's been done, so it's a fraction of a % of what has already been invested.
Right.
Absolutely, and looking at the big picture of the contract, that $28,000 is approximately 0.12% of the worth of the $24 million contract. So while we understand that it is an additional expense, we're hoping that your client is understanding to the idea that this is a small fraction in terms of overruns that could potentially have been significantly more.
So if I'm just understanding you correctly, I think you're on the same track as I was, Josephine. Are you guys about to, or are you guys insisting that perhaps our client pick up the overrun, the additional expense?
We could discuss that. We do think that would be fair, considering that it was a legitimate overrun, and the subcontractor, we certainly don't want to make the subcontractor have to eat that cost or have a dispute with them. And we also think that it was part and parcel to making this project, because it is a large project, because it's a high-end project. We want to make sure that it's done right. And so this concrete work was essential.
We can definitely talk about the potential for our client or your client to share that responsibility. However, I just wanted to make sure that I'm understanding correctly. So $63,180, and the overrun was $28,000. Is that correct?
That's correct.
Okay.
So the $63,000 minus the $28,000 is a legitimate cost that we intend to pay. We just want to make sure that we can pay them all at once.
You're strictly asking for 28.
In
The rest of
regards to the
value,
concrete.
Exactly.
Exactly.
Okay.
Exactly.
Just to make sure. I'm glad we can clear that up. Thank you again for being so clear with us on these issues.
Absolutely, absolutely. That's our intention. And with the roofing, this was the really complicated issue, because this one there was some concerns with the contractor, the subcontractor. While the subcontractor was doing the roofing work, which they billed us for a total of $165,000, they did $26,300 worth of damage to the framing, and so that was framing that Wilco had already done. And so in that regard, we've been more insistent to take a stand with them to make sure that they pay for what they've done. And so we are trying to negotiate with them, and we're considering litigation with them, but it is going to be a cost that needs to be come up with. But that said, Wilco is going to do the work to redo the framing on its own.
And to be clear, Wilco did pay the roofing company. They just did not pay them $26,300 for the damage that they caused for the framing.
Correct, but it's my understanding that Wilco is asking the owners to pay that cost for the damage?
So we would like to, as you said, in the shared responsibility, we'd like to discuss some options. We have some creative ideas of how to offset that. For example, if the owners could help us pay that now, we, in the process of trying to negotiate a settlement, or if we do have to resort to litigation, we would then give the owners all the monies that we received minus legal fees, for example, because we do not intend to profit from this mistake in any way, and we are going to bear the cost of repairing the framing. We just want to make sure, A, that we're sending the right message to our subcontractors that this type of thing won't fly with us, and also make sure that we aren't eating an unnecessary loss.
And just to echo a little bit of what Anton's saying, the idea is that Wilco plans to pursue an individual claim against the roofing subcontractor on a matter of principle, and that's going to happen regardless of what agreement we come to today.
Right.
So if that ends up in litigation or a settlement agreement, if Wilco, or if Progressive would be willing to front the $26,300 to remove the lien in the interest of keeping construction going, whatever result, whether that's $26,300 or more, minus the attorney's fees that it costs Wilco would be more than happy to pay that award to Progressive.
I see as like a good faith showing that they don't want to make any profit off of this
Precisely.
issue.
Absolutely, that's exactly
And
correct.
we think
Josephine.
we think it's absolutely right for you guys to stand up for yourselves and make sure that no subcontractors kind of walking all over you or your reputation, because it is your reputation.
Absolutely.
And we're sorry to hear that it might take litigation to get it done, but we're happy to hear that you guys are on top of the ball.
Thank you so much for summarizing the situation regarding the liens. It's so much clearer now what's going on,
Great.
and it's great to hear where you're coming from. Going off of that, I would like to know, or we would like to know more about the current status of the construction. The last time we were informed, it was the 5-month mark, and it was 40% completion. So where are we now?
That's a great question, Josephine. Currently, we're at a 5.5-month mark, and the Brownville is 40% complete. Due to some of the damage to the frame caused by the roofing and the conflicts that that's caused with the subcontractor, the Brownville is currently running a month behind its predicted time completion.
Yes.
And the Paris Springs is right on time. Within 2 weeks, it will be 50% complete, right on key to be done in the year's time.
So what percentage we can assign it now is just, I guess, roughly 50% in 2 weeks. We don't really know what it is now, at roughly 40, 45.
Correct. So it's on track to reach that contractual obligation of the 50% at 6 months. And so the real issue, as Danielle was saying, was with the Brownville hotel,
Right.
and that was because partly of this roofing damage and the fact that some of these liens, as you know, our client was becoming aware of those. Also, those have to be resolved, and so those things do take time.
Mhm.
But again, it sounds like our shared goal here is to get these done as efficiently as possible and try and not prevent any more overruns if possible.
And if these lien issues are effectively and quickly resolved, do you think we'll still be meeting this 1-year deadline?
Our client absolutely sees that the Paris Springs is going to be complete in the 1 year's time. However, as Anton said, due to some of the issues that have arisen with the framing and the liens, at this time, the Brownville is expected to need a 1-month extension.
1 month.
And we do know that your clients were interested in a staggered start to construction before entering this contract. Are they still willing to be flexible in regards to that? Is a 1-month extension something your client could be
So,
amenable to?
Let me take that question if you don't mind. I think our client, the reason we were interested in a staggered approach to this is because doing these ventures, these 2 really large hotels, is very expensive, and it's a huge issuance of trust when they ask the general contractor to take them on at both times, right? Both at the same time. Those were the assurances we received from Wilco, along the lines of, don't worry, we'll be able to handle it, we can do them spontaneously, we can start them at the same time, we'll finish them at the same time, we don't have to stagger start and stop dates. That's why I think the owners decided to go ahead and allow for the same time. I mean, particularly, to be honest, to avoid issues like these where damage could come up, delays could come up, etc. The staggering typically helps in that regard. Now, when you say, are we still flexible, what exactly are you asking?
Is a 1-month extension something that your client could provide
Is this on only the Brownville property?
on only the Brownville property?
I think it is definitely something that we can consider, but we can come back to it when we look at this as a kind of a full picture deal.
And Josephine, we're really interested to know, so our client was shocked to hear about these liens. He thought that any disputes between subcontractors were being handled independently. Did anyone at your client's business or anyone associated with Progressive Hotels have any knowledge or reason to know that liens were being filed against the properties?
I think we were just as outraged as potentially your client was, which is why the owners of the building, Bill and Pete Patterson, they called Danny Williams, the owner of Wilco, and quite the outrage, right? That's information I think we both have, and that was because they were not aware of these liens, and no one told them, where they kind of expected the general contractor, which is typically GC's job, to let them know when a lien shows up. It's like, hey, we've got a red flag, we're putting you on notice, we're trying to handle it, right? That's something that they would typically want to do. Before Bill and Patterson gets to the bank and the bank says, hey, we can't give you a loan because there's these liens, right? That's not the right way Bill wanted to hear about these liens.
Well, and it's definitely not the way our client wanted to hear about
Exactly.
them as well. He had absolutely no knowledge that liens had been filed. He thought perhaps that since your clients owned the property, they had been notified that the liens had been filed, but it
No.
sounds as though they had no notice.
No, from what we know, they did not have notice, and he was very surprised to hear about them.
Okay.
Right, which is something we will need to address moving forward. I think that's part of this agreement we're going to work on today.
Right. One, it was certainly a surprise to have it happen so close to getting the loan, right? And so there is this
Right.
time pressure. Could you express more in terms of coming up with some of these funds to remove the liens Does Progressive Hotels have cash on hand that they would be able to help us with these concerns?
I think first it depends on the amount. I know that you've listed out two amounts regarding the 28,000 and the 26,000 figure. Is that correct?
And as well as the plumbing figure, which was the 7,780. And so all those put together, considering the fact with the concrete that we're simply discussing the overrun, not the entire lien, that total comes out to $62,080.
$62,080.
Correct.
That's correct.
And so those are the liens 3 through 5.
And to be clear, the idea that we expressed earlier where Wilco would be more than happy to return or provide whatever sort of settlement or damages it receives from its personal claims against the roofing contractor would mean that $26,300 of those dollars isn't something that Wilco is just expecting for your client to pay. Was that clear?
You're right, assuming they win and are rewarded that exact amount, correct. I think there's other options that we can consider. I appreciate that creative idea, it really is, it's a good idea. I'm not entirely sure the owners will be willing to wait on litigation and necessarily just that amount, especially if they're funding more money, they might want to receive it, or at least receive more of it than just the $28,000, especially on the contingency that you win. So you can see where there might be some red flags for the owner. Just for transparency reasons, I'm bringing them to your attention now. So when we come back and maybe say something else or offer a different creative idea, you don't go, whoa, what about our litigation idea? I'm explaining now that maybe it won't work.
We understand that the timetable for litigation
Right.
or a settlement can be long, and we understand your client's concerns about that.
Cool, well, I'm glad we're definitely making progress. This is fantastic information trading.
I think at now we want to come up with some of these more creative ideas. So one of the things that we really want to accentuate is that our client is very concerned, and Nick and I want to go back to our client and tell him we now have faith. We are now confident in Wilco that they will finish this project and the liens will be cleared. Just going forward, we
Right.
want two amazing properties to come out of this deal. So a couple of ideas that we have thought of is first, a financial supervisor, someone that looks over the finances that Wilco is using to pay these subcontractors to make sure that the payments are, given on time, that there won't be any liens going forward.
Right, so something like that would ensure that we know, let's say monthly, right? The idea is, it takes a load off of Wilco, right? We're not asking Wilco to provide us these monthly assurances necessarily. We'll have a financial supervisor kind of on site who can watch and take that. It's not extra work for you guys.
And may I briefly ask, would they be working with our account manager, with Wilco's account manager?
Correct.
Okay.
They would be working with your account manager, they'd be working with the subcontractors. They're going to have the most full picture of what's going on, and they're going to forward that picture to the owners, so the owners are never caught in the dark again.
We really appreciate that. And is this something that Progressive is willing to fund?
Correct. I don't know if we can fund it, but the idea is it's not going to cost you much, if anything. The idea was 1% off of the installment. So 1% off of the next $4 million installment is roughly $40,000 is what we would pay the guy. I think that's a very acceptable number. And again, 1% off of the final installment just for his continued work is another $40,000. He'd make a total of $80,000 off of each of these hotels. So a total of $160 actually.
Do you think that going back to Progressive and explaining the fact that these liens were for some legitimate reasons would help put them at ease, as opposed to having to pay an extra $80,000? Because with that $80,000, we could address these liens and get back on schedule, at least for the Paris Springs hotel. And as we mentioned, unfortunately with the Brownville hotel, there's just going to be an overrun of 1 month. Would it not be better to put that money towards the actual liens, get those cleared, get construction moving again, and then moving forward we could discuss perhaps showing you what kind of expenses we're coming up with for our subcontractors, and that would put the onus on us to give you that information without hiring another personnel.
It sounds like you're concerned with the liens first, and I agree with you. I think those are a concern we can address first. I totally understand what you're saying. Those liens are something we want to address as well. If we can't get those liens lifted, we can't get you the loan and the money you need.
Absolutely. And to be clear, without distribution of the next set of funds, Wilco's not going to be able to hire additional subcontractors to keep moving forward on construction. So that is really why it's very important to remove these liens. And I understand, Josephine, that you mentioned your client is concerned about whether or not Wilco is going to be able to live up to what it said that it's going to be able to do. And I think we'd like to emphasize that it was at 5.5 months that your client was notified of these liens. They immediately called our client. We're still at that 5.5 month point. and 4 of the 7 liens have already been resolved.
Right.
Our client is dedicated to making this project happen, not only for its reputation, but to get your client what they promised.
Sure, if this fiscal supervisor idea is something that you're, I guess, not as open to, a couple other things that we thought about was potentially Wilco getting a monthly title search. So what that means is they go, they check the title, they see if there's any liens on it. So on a monthly basis, we know if there's a red flag, we get early warning. It's good for both of us, and it doesn't really cost much, maybe a couple dollars.
As you said, Anton, you guys have an accounting supervisor keeping track of these numbers, and I'm assuming your payments to these subcontractors, what they're being paid for, and if your accounting expert is, worth his grain of salt, he's probably doing that on a monthly basis. If that is the case, it would have hurt him none to forward that information to the owners, and that way we could prevent the financial supervisor from coming in and cutting out of your 1%, if that's really what you want.
We definitely appreciate that, and we think that cutting out that 1% will help us resolve these liens. But I have to ask, why would your clients not run title checks on their own properties? If this really is such a cheap and inexpensive thing, considering they own the properties, why wouldn't they be willing to put the onus on themselves?
It's kind of like the issuance of trust. When we trust the GC to do the work and get it done with his subcontractors, it's kind of up to the GC to make sure his subcontractors are being paid and not filing liens against the property. It's not so much the owner's job to manage the subcontractors.
It's not his job to manage the subcontractors. We definitely agree with you there, but considering they own these properties, just being aware of what's going on the property they own is important.
I understand your concern, and I think Nick makes a great justification for why we would love for Wilco to make that. It's just another thing, going back to that theme of us restoring confidence in Wilco to our clients. Going back saying, Wilco is willing to title search month by month because of this lien issue that we have. They're going to be really happy.
I think you would something. The owners are, again, outraged. We're not outraged. We're their counsel. We're trying to work with you to make this problem go away. I think that's something they would really respect. It's a creative idea that would probably cost you little to nothing. You file something with the Secretary of State, for instance.
And it sounds like what you're saying is that these monthly title searches are relatively inexpensive, and you said it might be as little as a few dollars.
I believe you just go to the government agency that has the titles and you check whether or not there are liens.
Right, it might be the Secretary of State or a website or some kind of database search, etc.
Well, we can come back to this idea. I think that that's something that might be inexpensive
Absolutely.
and possible.
And if this would provide your client with reassurance of our client's dedication to this project, we think that it's something our client would agree to.
Yeah, cool. That's really good.
And also, we'd like our client would like to express that these liens for the dirt work, gravel work, as Danielle had mentioned, were just something that got overlooked, and those payments did get resolved immediately as soon as they came to our attention. And the concrete, again, was an actual overrun. It wasn't anything that was foreseeable. It was just something that happened in making sure that this construction was done right.
Right.
And again, with the roofing, we just really have to put our foot down, and we're really happy to hear, and I know our client's going to be happy to hear that you are supportive of that as well.
I know you said that there were little misunderstandings with the dirt and the gravel. And so I know that we mentioned it briefly, but when you pay your subcontractors, having them sign a lien waiver would be a really good way to, restore the confidence again. Make sure we paid you, sign the lien waiver, there won't be any liens on the property.
That's a really creative idea.
Absolutely, and it's super helpful for both parties. That way they haven't filed a lien, we know they haven't filed a lien, because we're definitely getting copies of these lien waivers. They're getting paid, and that's essentially what they're saying. I'm paid and happy and not going to put a lien. That's right?
We don't have information about whether or not that's something our client has authorized us to agree to today, but we think it's a really creative solution to prevent this moving forward, and we will definitely take this request back to our client.
Please recommend it to your client.
Exactly.
We think it's a great recommendation.
We would say that the lien waiver obviously still wouldn't address these issues with, for example, with the roofing company, where there was a legitimate dispute, where they're trying to foot us with the bill, even though they did cause this damage. And so obviously those things would be unavoidable. But again, this was the only real concern that we've had that was something legitimate, where the subcontractor actually did some wrongdoing. And again, with the plumbing, we think we were double billed. We'd like to see that itemized receipt, but since it is a smaller sum, it's something we thought that Progressive might want to just pay and get rid of.
And it seems we have a lot of mutual interest here, but given for the sake of time, we think it's important that we move the conversation back to how we can get these liens resolved as soon as possible. It sounds like your client might be flexible with giving this 1 month extension, but in order for that to be the timetable we're working on, we need to get these liens resolved as soon as possible, and that's going to take coming up with some creative ideas for how we can get them done.
Danielle, I totally hear you. I think the liens are a priority for you guys. I think they're a priority for us as well. We're definitely going to go ahead and address how we can handle that. I think that's something we need to address before we can talk about necessarily even the implementation of creative ideas or the many assurances our clients asking for. As we haven't really even spoken about those, we briefly mentioned them, like maybe monthly lien waivers or monthly accounting statements from your accountant. Those are kind of the assurances they're asking about. We can get to all of that stuff after. We've got a lot of new information now, I think. It would be a great time for us to kind of contact our client, ask and see what he's available with. I do want to preface that though. You are asking for help paying for these liens. We understand why, and I think you've given us a good reason, which is maybe we just want to get them off the table and keep moving forward. I will tell you right now, we can't get a loan from the bank. We don't have much cash. It's going to be difficult to help you pay for all of these things, especially when the owners are already very upset. We have to have incredible justification to ask for money. I just want to walk into the caucus with that in mind.
We thank you for the transparency and knowing that your clients don't have a lot of cash right now. That's definitely something we'll relay to our client. We can come back in a few minutes and think of a creative way.
I appreciate it.
Thank you. Thank you so much for providing us so much information on the situation. We really appreciate your transparency, and we hope we can make a deal. Nick, do you want to talk about what we came up with?
Yes, so there were a few things. On the 3 liens, let's address those first, get them off the table. I think that's what would be best for both parties here. I know that's something you guys are excited to talk about. So let's do with the one we will definitely help you with. Concrete, the $28,000 of overrun, the extra materials required, it costs extra labor. We are authorized to help you pay for that, and we will in full.
Great, we're happy to hear
We'll
that.
knock
Our
that lien.
client will be really excited to hear that. Thank
Good.
you so much.
You're welcome. I'm glad. We're trying to help you solve the problem as well. It's a good teamwork thing.
Absolutely, and our client is trying to get these liens resolved as soon as possible so that they can stick to your client's deadline in terms of getting these hotels under construction completed as soon as possible.
Excellent. And hopefully we'll never end up in this room again.
Absolutely.
Second, regarding the $7,780 number, we can't pay for that because if you're really, really sure that you've been double billed, I think that there's a sort of responsibility you should take on your side to make sure that you get your itemized receipt, you prove that you paid it. Even if it's through a bond, you'll get it back if it was paid.
We also understand your reasoning about how the owner might just want to flush it off the table, and that's not necessarily incorrect reasoning, but within our authority today, we cannot agree to anything that wasn't strictly necessarily an additional necessary expense, which this is not, unfortunately. The overrun is, for instance, which is why we're happy to help you pay for that.
Thank you for that, Claire.
Thank you for being so clear and transparent about that. If it is something that your client can't authorize you to pay for, our client will be prepared to pay for it.
Particularly if we can come to some agreement regarding this roofing issue, because there is a little more confusion as to whether that's a legitimate overrun, right? Because there is the idea that Wilco will be repairing the framing, and obviously that framing wouldn't have been damaged if it weren't for this roofing company. So sorry we cut you off a little bit. Could you continue to describe what Progressive might be able to do regarding the roofing?
So this is something you guys have brought up to the table, and we liked it, whether or not we would pay and then you would pay us back based on your litigation. Having said that, we had a different idea that we think is equally as effective and probably faster for both of us. What will happen is we will front you the $26,000. It is a front, an advance. In return, it will come out of the $4 million installments. Okay, it's just $26,000. You're receiving $4 million. It's a tiny fraction. And if you want, we can split it up half and half. Half in the first $4 million installment, half in the final $4 million installment. That way you don't feel the brunt of it all at once. Although I hardly expect $26,000 to make much brunt out of $4 million.
So to clarify, Nick, Progressive is willing to give Wilco the money to pay that lien, but
No.
they're not willing to contribute to the lien over the long term.
Correct. The damage is certainly not the owner's fault, right?
Absolutely, it's not the owner's fault, but as Anton's touched on, in the construction industry, sometimes things happen and damage is done and additional expenses come up, and our client views what's been done to the roofing as an additional expense that wasn't anticipated in the budget.
I appreciate that, but I think as we've discussed with our client, the GC typically has liability insurance for things like this. They typically have other routes like settlements and litigations for things like this. It would be rare and unusual to require the owner to pay for damage that the GC should have covered.
Actually, Nick, great idea on the insurance. Do you have liability insurance, or does that subcontractor have liability insurance that you can claim to if they really did make that damage?
So that's not information that our client has given us at this point. But you raised a point earlier about this not being Progressive's fault, and we understand that. And it also wasn't Wilco's fault, but Wilco is willing to put in the labor to repair this issue. The fact of the matter is that this $26,000 lien just needs to be paid, and then we would go after them to get it back, and that money would still be coming back into Progressive Hotel's pocket if we can recover the full amount. So in that sense, it's nobody's fault. The issue is getting this paid so that we can move forward on construction. And so if then we aren't able to recoup, we've not only done the labor, but we've also eaten the entire loss from this roofing company. And we think it would be fair for us to share in that, but it sounds like that's something that Progressive is unwilling to do.
Anton, not only that, but let's just talk about this logically here. If you go to litigation, that's going to cost you money, a lot of money. They're going to have to pay, no offense, you guys, right? They may not want to do that. If we give you $26,000 now to make this lien go away, you don't go to litigation, you don't pay expenses.
Well, to clarify, Nick, as we expressed earlier, our client is set on pursuing some claim against the subcontractor regardless of what deal we come to today, just for the principle of the matter. Not only did they set back the construction timeline, but they damaged the property that's your client's, the property that our client is working hard to build on a timetable. So while we do understand that litigation can be expensive and hiring attorneys can be expensive, this is something that our client plans to do.
And
If he's very confident and is willing to go to litigation, and he's confident in the fact that they made the damage, then he would be pretty confident that he'll be winning the litigation, correct?
Not only that, but he could do it in such a way that we do it with this advance, right, where you receive your $26,000, you pay back during the installments, and then you keep the money from the litigation. And we understand why you'd want to go to litigation, especially for the reputational harm. We get it. It's just going to be expensive, and we think if you're confident in your win and protecting your reputation,
You can keep the wins.
keep your own wins.
yeah, and as you mentioned, litigation would be expensive, and there is this issue of principle in terms of pursuing that claim, and so there would be some incentive to settle. And so if we did settle, it's unlikely that we would receive the full amount. But that said, maybe we could go back to this idea that you were discussing about what we could do in good faith about the monthly title search. I think that was something that we were discussing outside with our client, and it was something they would be amenable to if it is a low-cost option. Would that satisfy that concern of Progressive Hotels?
Yes, I mean, those are concerns separate and apart from these liens, but yes, moving forward, we would like assurances that there are no additional liens being placed on a monthly basis, which would definitely be good, that you guys are doing these monthly title searches. That's something that would be, I think, good for both parties.
Were
That's
you
good to
able
hear.
to talk to your client about the lien waivers? Whenever you pay the subcontractor, you do get a lien waiver?
Our client didn't have any information at this time, but that is something that they will consider, and we'll be able to provide more information on another time. If it's something that's absolutely crucial for your client, we'd love to hear that.
Just to recap what we were saying regarding this 26,000 figure, so we're saying we're gonna advance you that money so that the lien goes away, so that we can go forward with the project. However, that 26,000 will be coming out of your next installments. However, you keep the winnings from your litigation.
Or settlement. Ideally,
Or settlement.
So ideally, you're still making half your money back, right?
So if we're hearing correctly, it sounds like you would be able to help us in the short term to at least get these liens cleared.
Correct.
And then if we do recoup any of those monies, we would be entitled to those.
Right.
And Progressive Hotels is willing to pay the $28,000 of the legitimate
And
concrete
we've offered to
overrun.
pay that in full in good
Great.
faith.
Right,
Absolutely.
So in total, $54,300 will be going to you, and $26,300 will be coming out of it from your installments in the future.
And then conversely, Wilco would be paying the plumbing fee, even if it goes over. I think that our client has expressed to us they want to make sure that these liens go away, and they're prepared to simply pay that and get it out of the way. And we're
That would
happy
be
to hear
wonderful.
that we're making progress.
Great.
We've absolutely, I'm sorry, Anton, we've been making really good progress, but all of this can't be possible if we don't have a 1-month extension. Were you able to talk to your client about that? As we expressed earlier, it's going to take an additional month to complete the Brownville property.
Right.
Is that something that your client?
So we definitely talked to it with our client. There's a couple other things regarding this restoring the confidence idea that we keep going back to. So one of the things is, once the liens are all released, we would love documentation to go back to our client with. Here you go, Pete and Bill.
Yeah.
Here are the liens, they're cleared, we can go forward. We would love documentation on that part, just help recoup that confidence.
Right, and I can tell you that'll immediately lift their spirits.
Definitely.
That's something that our client would be more than happy to provide, especially if it will provide your client with reassurances that,
Exactly.
that we're all operating in good faith here.
It goes back to that word, reassurance, or better yet, assurances. Our client is looking for assurances that this won't happen again, and that what has already happened is on its way to being out the door, right? There are a few stipulations to that. It's not much worse than what we've already given you. So when you get rid of these liens, they must be, let's say, confirmed to have been removed by the 50% mark on both buildings. Now let me specify, because that's important. Just because, let's say, the Paris Springs building is very close to 50%, doesn't mean all the liens have to be lifted. We said both buildings. So only at the time that you have both buildings at 50% must all the liens be lifted. That gives you a little bit extra time, kind of wiggle there if you need it, if necessary. Now mind you, it sounds like we've kind of handled all of these liens on the table, right? The 3 remaining. We're paying
correct.
for one, we're giving you an advance for the second, and then you guys are handling the third smallest. So there really shouldn't necessarily be any wiggle room necessary, but we're offering it to you. We just need assurances by the 50% mark that all liens have been handled.
And
with
that's
one.
by the time both properties are at 50%
Correct.
complete. So if the liens get cleared and construction goes according to plans, we're looking at 6 weeks. Is that correct?
How did we get
So,
to-
so if we could clarify as well, the estimation for the Brownville property is that because of this delay due to these setbacks, there would be a 6-week delay in getting to that 50% mark. In other words, the 4 weeks, the month extension that we needed is to get to the 50%. So if we could have those 6 weeks to clear these liens, that seems like it would be more than enough time. As we said, the checks are in the mail for 4 of them. And with this roofing issue, although we don't love giving money to people who we feel might have burned us, we would do it and then pursue the litigation afterwards, or a settlement, and those would all be resolved. So I think in 6 weeks that is doable.
So Anton, you're saying that if we give you that 1 month extension, you can assure us that at the 50% mark, all liens will be cleared.
That's not exactly what Anton said, and just to reiterate what he was saying, we anticipate that the Paris Springs property is going to meet its 50% obligation in 2 weeks on time. As we've articulated, the Brownville property is currently a month behind schedule, so
Right.
it would need 6 weeks to reach that 50%. So we were just trying to clarify, are you asking that all liens be removed in 6 weeks?
No, Danielle, I think we're on the same page. We're just kind of sending the same words back at each other. They mean the same stuff. You're getting the extra month.
Okay.
If that's 6 weeks from now, that's 6 weeks from now. I believe because we're at 5.5 weeks, that would be 6 extra weeks.
We're just trying to clarify if those,
Totally fine.
within those 6 weeks is when you would expect all the liens.
Yes.
So that's what you're asking for.
And as far as we know, again, once these would be paid, there's no reason for us to believe that those liens wouldn't be cleared. Do you have any information as to some of these conflicts? Have you heard anything else that they would take longer than 6 weeks?
No, we have not heard anything like that. It's just going back to the reassurance thing, we definitely want, at the 50%, we need that $4 million to go out to you so that you can continue with the project. We just
Right.
don't want these liens there, so we just want that assurance from you.
We understand that, Josephine, and we definitely don't want those liens there either. Clearly, your clients can't get the additional loan money they need
Correct.
with the liens there, and our client can't continue construction without the liens there. However, it is a lot to ask, not that our client, and I know we're working really hard here today to figure out a resolution between our clients in terms of clearing these liens
Right.
and moving forward, but just because our clients pay, we can't control what subcontractors are necessarily going to do. So asking our client to provide assurances that in this 6-week window, everyone else that's not at the table today will do their part and remove these liens. We're just worried that's not something that's entirely in our control, even if we're all operating here on trying to put the money forward.
Without interrupting you, and I apologize, let me just specify that we're discussing the current liens. We understand you guys do not have control over the future liens. We're not.
Oh, and just to clarify, I was not insinuating that there would be
Right.
future liens, but just the people who filed these liens
Right.
aren't here today, and we can't necessarily control their actions.
No, but liens are naturally lifted when they receive
Right.
payment.
So what we could guarantee is if everyone's willing to make these commitments in terms of making the payments, all the payments will be made. But can I briefly ask, moving back to the to the Paris Springs development, that's going to require that the loan be made in the next 2 weeks. So as long as the dirt work and gravel, just those 2 liens on the Paris development are lifted, that 4 million loan can still go forward as planned in the next 2 weeks, is that correct?
I believe the liens are tied to the bank loans. I don't think the bank will provide a loan unless the liens are lifted, which is why we have the 50% assurance.
For all
Yes.
properties?
Correct, because the bank is insuring both.
So then what we really need to discuss is whether we can get all these liens lifted in the next 2 weeks so that the Paris Springs construction can move forward. So, but what we can say is, as Daniel was mentioning, we can definitely guarantee that if you're willing to help us with the advance and pay for the overruns, all checks will be written immediately.
Right, and I think that's why we kept talking about the documentation, the records, the title check, because we want to have a check and balances. You guys are obviously going to go do your part in best faith effort, and we want documentation that that happened, so that the release can happen and that we can go forward.
Okay.
That's great to hear. And so just to summarize, it sounds like we've agreed on a number of issues. We've agreed that the four liens that were to another subcontractor have already been resolved and are no longer
Right.
an issue. Those should be cleared soon. The checks are already in the mail.
Mhm.
In terms of the plumbing lien, Wilco is going to front that lien just to keep things moving. The $28,000 overrun for the concrete is something that Progressive Hotels is willing to pay, as this was a legitimate overrun.
Correct.
And the roofing, the regards to the $26,300 amount on that lien, Wilco is going to pay that with monies from
With an
Progressive
advance.
Hotels.
Right, we'll
Right.
be giving you an advance.
Which
And
will
do-
be pulled from the installments.
Right.
But if, and
And any litigational
Okay.
awards go back to you guys, not to Progressive.
if that is sent to Wilco as soon as we leave this meeting, we see no reason why this can't be resolved in 2 weeks.
But we don't have a total agreement, yes. There's a few things left on the table. So before we, snap up our books and walk out the door, 2 weeks we think is fine. But there are a few other things like the assurances we were talking about earlier that we would still need. I haven't heard from you whether or not you said it would be okay
So
for your accountant to
in-
kind of send that information.
So with the accountant, we can certainly work with the accountant moving forward to give you information
Perfect.
about the subcontractors. And again, if this monthly title search, as you said, is something that's relatively inexpensive,
Mhm.
as a showing of good faith, I think we can certainly agree to that. Our client would be amenable to do that for the next 7 months, I should say.
Right,
of
let's just
construction.
say until completion, just for simplistic sake, and then on a monthly basis, not only will your accountant take on the additional responsibility of the lien search, but he will send an accounting, right, of what work was done that month, what it
was
cost,
paid.
and what was paid. And that way we know, right, we know if there's a red flag. I think that's something he will naturally keep in his Excel spreadsheets that he can send forwarded in an email. It'll cost him nothing and satisfy our clients greatly.
Absolutely, that's definitely something that our client is willing to
Great.
do, if that would reassure your client,
Totally.
such that we can make a deal on the other terms that we've specified. I think that this is going to be great for both of our clients moving forward.
That sounds great. And one more thing, the recommendation going forward will be regarding the lien waiver. Whenever you guys do make payments, would make things go greatly and smoothly going forward.
We think that's a great idea, and as soon as we talk to our client about it, we'll give you a call and let you know what they say.
Sure, we'll get everything drafted up that we agreed to on today. We'll send it your way, and we can definitely make sure that everything goes to plan and we get this project completed.
That's great to hear, and
Yes.
just to let our client know, when should they be expecting the $26,300 so they can meet that 2-week deadline?
Certainly within the next 2
The
weeks,
next 2 weeks.
probably sooner than later. We can tell our clients that the urgency is the issue here, so we
Great.
will have them send it as soon as possible. That's a recommendation we will make.
Okay, well, it was wonderful.
Thank you
meeting
so much. We
today. Thank you
appreciate
so
it.
much.
Excellent, thank you guys.
Thank you so much, Nick.
Thank you, Danielle. Thank you, Anton.
Thank you.
Thanks a lot.
We have 2 questions to answer for you today. The first one is, in reflecting upon the entire negotiation, what would you do the same and what would we do differently? Nick?
So something I thought we would do the same was take the same opening introductory approach. We definitely tried to establish the tone of the whole agreement, the negotiation, the conversation, et cetera, at the outset. We did not want to have this potentially contentious fact pattern become a contentious negotiation. That would be the worst way, I think, to suit our clients' needs. In that sense, at the outset, we established that we are separate entities from our clients, though we represent them and they have serious concerns. We are professionals here today to try and form an agreement that ideally turns this dispute into a deal, right? That's the best way to kind of handle it.
I think another thing that we did really well is information gathering. The fact pattern had a lot of information about liens, but we had no idea how they occurred, what happened. So we definitely inquisitively asked multiple times, what happened with this one, what happened with that one, what timeline was it, when will we be getting paid?
Right.
And I think going off of that, we also actively listened, making sure that we get every single detail. And Nick was really great at parsing out. Whenever Antoine gave a really long answer about what happened with the lien, Nick was able to succinctly kind of overview it and make sure that we got the important details of that explanation.
Thank you. Yeah, and I think we definitely did a good job in our information gathering phase. I can hardly remember asking questions, but I think you took over most of that responsibility, and I appreciated it. I think Josephine asked key questions that were important to our client, as she highlighted that we were kind of left in the dark as to why we didn't have money or why there were liens against our property, when this would be solved. Josephine asked all the necessary questions within the first about 10 minutes, so we had a lot of time to kind of dwell on this and start thinking of other ideas and perhaps ways to solve these liens. It became very apparent, I think, to us, using this information gathering phase, that the liens were their priority on the table. They really wanted to discuss those before they discussed anything else, and I think that kind of framed the rest of the negotiation.
I think one last thing that we did well is tons of creative options, and we'll definitely explain that more to you when we explain the problem-solving strategy that we implemented.
Right. So what would we do differently?
Let's see. I think sometimes we got a little bit bogged down in, I guess,
Some of the numbering.
yes, the
some of
numberings,
payments,
and then
right.
maybe not pushing back enough, because their first offer was well within our range. We had $100,000 to spend if there was necessary work that needed to be done, and their first offer was well below that. So maybe we could have pushed back a little bit more and said, no, less money, so that we could save for our client.
Right.
But of course, we took the collaborative approach, so we didn't want to push back too much.
I think that's something that we addressed during the caucus. That's specifically why we took the caucus then. We wanted to, which I think was well timed. That's something we'd probably do again. Right after the information gathering phase, before everyone gets to their offers, you'd want a caucus to address A, the other team's negotiating style, whether or not they're being collaborative with you or not, and B, when it's time to make your own offers, where to kind of stand on that. And I think we made our offers in good faith. We did not want to lowball or highball them. We didn't have to necessarily disclose that we had $100,000 to deal with, but their opening request was so low, I didn't find it necessary even to kind of stonewall them and potentially prevent the agreement or push it off past our time limit today.
Did you consider whether you needed to save anything from that $100,000 for the second half of the project? I mean, did that even enter your thinking?
Yes, exactly, and that's why precisely we didn't even spend. I think we stayed under even $50,000. We had $100,000 in our budget. We agreed to the 28 outright. The 26, which followed, was an advance, so we'll still be receiving that back in the next installment. In
So
fact,
this was a consideration? at the
correct.
time.
Yes.
Yes. We purposely kept our value low, preferably below 50, because of that. In fact, our initial offer, if we had to, was going to only be 50. It just happened that their request was below 50 in the first place. That's why it never really came up.
I think it was 60 something at first, and then we took out the 7,000.
Right. We kept knocking them
Yeah.
down a little bit.
Anyway, our second question is, what problem-solving strategies did your team use well, and how did they impact the outcome?
I think a lot of this goes towards the style of negotiating we employed. Throughout this competition, in fact, we've engaged several different styles, whether it be good cop, bad cop, relatively contentious and combative, or all-out collaboration where you act like they're best friends. I think today we kind of engaged them in a formal yet collaborative way, which was very helpful. I think when they realized we were not going to carry into this negotiation the anger and resentment that perhaps our clients may have, they were way more willing to work with us, and it, in a sense, took some of the pressure off of the conversation. It became more genuine in that
I
regard.
think if I were to title our, I guess, negotiation strategy today, it would be concerned but future-looking.
Right.
I just wanted to make sure, or we wanted to make sure that they knew our clients were concerned, but we need to finish this project, so let's work together. So we turned a dispute into a deal.
Exactly. So the other problem-solving strategy we definitely took was that we had specific phases. We had an information gathering phase, then a caucus ideally, and then an offering phase. And I think we did get there, though this wasn't necessarily the kind of negotiation that involves packages of lots of numbers individually. There were several issues that we needed to address, and I think we, A, gathered information on all of them, B, caucus to reanalyze where we stood on them, and C, easily framed an agreement based on that information afterwards.
And I think also one of our strategies was we thought there was two big, I guess, ideas. One is the financial aspect of the liens being released in the project going forward. And the second idea is to reestablish confidence in this partnership going forward so that we can go back to our client and tell them there are so many different things that we've implemented as a system so that this never happens again. So I think we came up with a lot of creative ideas, whether it's the monthly title check, whether it's the lien paper that when
The supervisor,
the
advance based on their installments, you're absolutely right.
Nick came up with the idea of advancing them the money and then taking it out of the two $4 million payments that will be made. So I thought that was a really great creative idea.
Well, I mean, we wanted to hit them with as many possible options as they could agree to. The idea was not to stonewall them or prevent an agreement today. It was in fact to help them get these liens, which were their priority, off the table as fast as possible. I think
Your client's priority too. You're not getting more money and your
absolutely
hotels aren't getting built.
You're correct. You're very correct. It just happened that our priorities lined up so well.
I have to ask you, why did you decide to give them 6 weeks to remove the lien without considering what the lien statutes say? You know, the lien operates independently of your negotiation. The perfection of the lien and all the things that we use to foreclose on the property, you should be well aware of that before you give them any time frame in which to pay. I mean, they are on their own track, having nothing to do with what you two, the two parties agree. So be careful, and have knowledge before you offer a time frame which maybe would be damaging to both parties.
What I wanted to ask you is, did either of you look up what mechanics liens, how they work, where they're filed, how you remove them?
I looked up how you relieve them, and there seemed to be 3 ways, which was voluntarily releasing it, posting a bond, or getting a court order. Those were the 3 things because we weren't sure where they were coming from, so we thought of ways we could release them, but to be honest, we didn't look at the statutes or how long they were going to take.
Right.
I would suggest you probably have enough time with Google today to get familiar with how the blooming things that you're talking about really do work in terms of how they get placed, how they get released. Your point about lien waivers, that's what's done in construction all the time. No lien waiver, no payment. So how the heck did these liens get placed on it?
Absolutely. I think we were probably under the assumption today that the voluntary release of these waivers would be the case if they had the money on the table today, which is why we tried to give them as much money to handle those liens. And that's the assumption we were operating under rather than having to go to court or file a quiet title, etc.
Hello, my name is Danielle Lauber, and today, along with my partner, Anton Swain-Gill, we represented Wilco in this negotiation. We'll begin by discussing what our strategy was coming into this session today and how that was effectuated over the course of this negotiation. Later, we'll talk about what we learned and how we would approach this situation again tomorrow.
So one of our key strategies coming into this was recognizing that there was a lot of numbers to discuss and there was going to be a lot of issues that we had to discuss. So one of our primary goals was to come into the negotiation with a really clear sheet of what kind of expenses we were going to have to discuss. And so Danielle did a great job of really listing those off, and we bounced back and forth to express exactly what we were talking about here today to make sure that we could resolve those issues.
There were a lot of numbers in play, and we wanted to clarify with our colleagues across the table what the current status was of the liens. We knew that their client likely had a lot of questions, and given the fact that our client had fixed some of the issues with most of the liens in a minute amount of time, approximately $102,000 of liens had already been resolved. That was something that we wanted to share with our friends across the table and let them know that our client was committed to moving forward and getting this construction project up and going.
And we also wanted to make sure that we were keeping the rapport light and positive because we knew that our clients were going to have to maintain this relationship. This was a huge project worth $24 million. And beyond just these immediate costs, which relatively speaking were fractional to the actual cost of the deal, there's a huge reputational opportunity cost for Wilco moving forward so that people know that they're not someone to be messed with in terms of the subcontractor, but also someone that you can depend on who's willing to make adjustments. And so that was one of our themes moving through this negotiation as well.
Absolutely. To echo what Anton said, not only is this a huge reputational interest for Wilco, but being able to manage these 2 projects at the same time and do them successfully is something that is going to be very important to our client moving forward in their business. So it was important for us to, as Anton said, maintain good rapport with with our colleagues across the table and find a resolution today.
And luckily that was easy to do. They were really pleasant to work with, and so they made it clear really quickly that they wanted to be transparent and really share information. And we saw that there wasn't many secrets, at least on our end, to hold. And so one of our ideas was part of our information gathering was to be information sharing. And so by making clear exactly what the numbers we were working with, exactly what kind of issues we had to address, we felt that helped tease out some of the information from them as well and come to a reasonable agreement.
In that vein, Anton did a great job information gathering, asking specific questions like whether or not Progressive had money to help with these liens. And we found from that question that yes, they did, but we also learned that they didn't have a lot of cash. And we definitely did our best to listen to what we were hearing about Progressive's financial state and try to find the best way for us to clear these liens. That's ultimately our client's number one goal. Not only can construction not move forward, but Progressive can't get money for the loans, and that was our number one priority today.
Absolutely, and clearing these liens, even though there was some cost associated to Wilco, was a win-win for everybody because it was essential, as Danielle said, to get things moving. And so we felt comfortable, and our client had advised us that clearing these plumbing liens on our own was something we could do, so we knew that was an option. And we also wanted to see what we could do creatively with the roofing. Although our client was prepared to make those accommodations, and they were going to do the repairs themselves, we thought that we were able to come to something really interesting by offsetting those payments and then reducing those later. And it came out to 0.3% off of each subsequent payment that would go towards the repayment of that advance. And again, if we are able to recoup those losses, that's a benefit, as well as letting subcontractors know that if they damage properties that we're working on, it's something that we take very seriously.
And in reflecting upon the entire negotiation, we'd like to emphasize some things that we would do again in the future and ways that we learned from this experience.
And building on this idea of repairs, the repairs did have a lot of value, and it was something that we feel like we maybe gave too quickly, that we were going to do these repairs to the framing, and it was something that wasn't necessarily a big deal. But we certainly think we could have emphasized that further, that this was money out of Wilco's pocket, it was time, it was labor, but we wanted to keep the conversation moving forward and not dwell necessarily on we're making so many concessions, because we didn't have many requirements from our client.
And it's worth noting that our client emphasized to us that they did not feel that Progressive should have to bear the brunt of the cost of the roofing, seeing as it wasn't just this overrun cost, it was this subcontractor's fault. So while, as Anton said, we could have leveraged for more money there, we thought it was really reasonable that Progressive was willing to put those costs up front and allow us to get construction moving again. And we didn't want to, as Anton said during the negotiation, take advantage of the situation and have our client benefit from it. It was just something that we wanted to work through and move forward.
Absolutely, and Danielle did a great job of illustrating how these sums related as a percentage of the total project, and that related to something else that we thought we might have been able to leverage more. As we mentioned, the fact that the project overall is worth $24 million, and as a percentage, these issues are not a huge concern. But we did want to listen to our colleagues across the table, and they made it clear they couldn't get an extra loan, and they didn't have a lot of cash on hand, so we felt comfortable proceeding in the way that we did.
And that's something that we would definitely do again in terms of listening to what we were hearing from our colleagues across the table and taking into account what they were saying. They told us from the outstart that they were not going to be able to pay for the plumbing, and rather than waste time saying, well, can you pay for $5,000? We said, okay, we understand that. Your client has not authorized you to do that. Let's talk about what your client can do for ours.
And that also builds on the idea that we think we got a good deal because we were upfront about our client's interests, and we made that clear, and that way we were able to just move forward and make sure that there was a good relationship moving forward in order to get these projects done.
And there were a lot of creative solutions at play today, not only across the table, but some of ours as well, and we appreciated the creativity from our end and our opponents across the table. And I think Anton did a great job of stating this idea of having a financial advisor that Wilco would essentially be paying for was not in anyone's best interest. If we were going to be spending $80,000 for someone to look over books that our client was more than happy to share and say, we have paid our subcontractors, here's proof of the matter, $80,000 would be much better spent lifting liens, not taking away from our client's bottom line.
Absolutely, but what we were willing to do is make assurances to Progressive, and so what we ultimately agreed to with talking about receipts of payments to the lien holders, to an accountant report, and the monthly lien check, we saw those as low-cost options that were reasonable, considering that there was some air to clear, and was something that wouldn't be a huge strain on our accountant, although it would be some extra time, is something that is fair and is something that is reasonable moving forward.
What would you do differently if you had this to do all over?
Well, again, I think we could have leveraged some points more. I think we also maybe would have had a clearer trajectory. I felt that at times we bounced around from different topics, but I think we did that at some points in order to move past topics that were difficult to justify. But I do think that there could have been a clearer trajectory.
And I'm asking this because, we're hearing what you did, but what would you do if you feel it appropriate, that you would do better or differently?
That's a great question, and I think one thing particularly that we could have emphasized is that, and Anton did this a little bit during the negotiation, is emphasizing that our client didn't do anything wrong here. We didn't divulge the information that there was an accounting error, but that was remedied. In terms of the $26,000 lien that was due to the roofing incident, that wasn't something that Wilco had fault in, and moreover, Wilco was doubling what they anticipated to spend from their own contracting business to fix these damages. So while Anton did briefly mention this, we could have stressed a little bit more. Look, this is costing Wilco too, and we're here today trying to move forward in construction, but this isn't our fault.
In analyzing this problem from a big picture, in the real world, whose problem are these liens?
Well, arguably, yeah.
Whose problem? How did you analyze that issue?
So we did see it as a mutual problem, because the loans from the bank simply couldn't go forward, and so I don't know if the Progressive Hotels is limited liability. Maybe I would still imagine it would ruin them financially, and for us there was a lot at stake because it would hurt our reputation, and we simply weren't able to pay our subcontractors.
Okay, but if it goes to court, is Progressive the one who's responsible for those liens, or is your client responsible for those liens?
The liens would be on the property.
I know, but if it goes to court and push comes to shove.
Right, arguably we could be responsible because they were our subcontractors, to be sure.
course.
The property is merely security for payment.
Right.
Of course.
It's not basis for responsibility.
I mean, and I think, when you're talking about what you did well and what you didn't do well, you somehow need to look at the real life big picture. The project doesn't go forward. Yes, they've got to get the funding, but if push comes to shove, it's your guys that are on the hook. And if you don't understand that, it's all just a game.
We definitely understand that, and our client understands that too, and that's why we think they'll be so happy with the outcome of this session, because they're getting a lot of money from Progressive to move forward in construction, and at the end of the day, they have the money in the budget to deal with the plumbing, so getting the other monies that they need to move forward resolved this issue, and it's not something that our client is going to be liable for in the immediate future.
I have two quick comments. First of all, I mentioned to the other side too. Be careful to agree on any kind of time period to satisfy liens, because they have their own time periods. They're statutory. It has nothing to do with the agreements between you two. Okay, so if you don't know what the statute is, be careful saying, oh yeah, give us six weeks, maybe you have 10 minutes. I don't know. Depends on when the liens are filed. It's not in the fact sheet. So be careful. The second one is, it isn't liability insurance. They shouldn't have, that's the wrong question for them to have asked. You should have responded, you mean property insurance. Liabilities if somebody slips and falls down. Property insurance when somebody damages the physical property. So it's really not liability insurance that's an issue. I'm not picking the fly crap out of the pepper. It's just that these are the kind of things, when you are a lawyer, you become more aware of. That's all.
See, this is a learning opportunity.
Absolutely.
And that's what it is. Treat it that way, no matter what.
Did either of you look up mechanics liens as getting ready for the property? I mean, today we have Google and Alexa. You can ask them. Did either one of you actually go and try to figure out how mechanics liens work?
I would say we did not do our due diligence in the research on the mechanics liens, and so our understanding was a little skewed, but we do understand now that that there would be that liability for the subcontractors as the primary contractor.
I mean, you're really walking into it with a lot of reputational difficulty.
Absolutely.
And you're on the hook for the money come what may.
Right.
And maybe the project doesn't get built.
In every negotiation, the reason you're sitting there, because both parties want it resolved. If they didn't want it resolved, you would have been in the courthouse. So
right.
you have a common interest in getting it resolved always in these kind of discussions. And if all they're gonna do in any kind of settlement is to come in and scream and yell and says, well, I did my job for the client, that's it, I'm walking out, you know that pretty quickly and everybody's wasting their time. But in this case, I think you had the right approach in terms of recognizing this as a collaborative effort.
And we really appreciate the work from our colleagues across the table and collaborating with us today.
A lot of it is a question of pet peeves for me, so let me start with that. Your opening question, how's your day going so far? Do you really care? Do you really expect an answer? You didn't get one? I mean, I know everybody does it these days. You can't pick up the phone without a solicitation call or an attempt to get something evened out without that. So I know it's the going thing. But think about it. What does it achieve for you? Particularly when you don't bother getting an answer or even wanting one. So things like that really peeve me terribly. If I were on the other side of a real negotiation with you, I'd be steaming and we would be off on the bad foot already right there. I'm saying that's my pet peeve, but don't ask questions that you don't really care about the answer to or even expect an answer to. At least that's the way I'd see it. The other thing that I think both sides did that I would really urge you to avoid is kind of narrative about what you're trying to accomplish. You did that. I'd like to set the tone from the outside. Really? Do it. Do it by how you speak. Do it by your body language. Don't telegraph what it is you're trying to do. Do it. Again, I think this is something that one sees an awful lot of, particularly among young people. I'm an old person, and I sort of think, really, where do they get taught to do these things? And I think it's ineffective. I think it really makes people wonder if that's what you really mean, or if you're pulling their chain, or if you're manipulating them. Just do what you want to do, but don't say, this is what I want to do. Slow down on your speaking. In the beginning, you were talking very fast. You did slow down later, but in speaking quickly, you misspeak. We could do it spontaneously. No, you meant like saying simultaneously. You said that the banks were not insuring the money. No, the banks were not funding it anymore. So when you speak fast, you're going to garble stuff like that. I also think you want to look at it from a bird's eye or airplane view before you assess the details. So you started out, for instance, by detailing all the liens. Are you really doing yourself a favor by doing that? You've got 7 liens, you've got almost $200,000. You didn't say that, you detailed them. Of all of that, you've already taken care of half of them. One property is completely clean. That's the message you want to get across. Not, look what a bunch of idiots we were. We managed to get $200,000 worth of liens, 7 separate liens on these properties that we had no idea about. When you're detailing it, that's the real message you're giving, instead of diffusing the other side. $200,000, $100,000, we've taken care of, it's all gone. We've got only 3 left. Here they are. Let's see what we can do about those. We need your help with it. Can you help us with it? If you want to set the tone of being collaborative by making that kind of statement up front, we can't take care of all of these alone. Can you help us with it? You're cutting to the chase, and you are really giving the message of what it is that you want and what you need and what you hope to get. So you're really being collaborative. You're putting your cards on the table.
Okay. I agree with your observations about technique. A few more things, though. You know, as I said to one of the parties here, that everybody's sitting at the table because they're not in the courtroom. And judges can order mediation, judges can order arbitration, judges can do all kinds of things. I think you were right to point out the minutia here, but you know the old saying, for want of a shoe, for a nail, the horse was lost. And in this case, you're both in the same bucket together here. You both need the bank. Whatever you've got to do to satisfy the bank should be the goal here. Because without any more money, everybody can all go home and they've really lost a lot, okay? So to that degree, you are in a collaboration. Whether you like it or not, you're all working for the bank. Because without that, there's nothing going on here. So I think if you take that kind of approach in these kinds of litigation, saying, what can we do to make the bank happy? It's not just what makes you happy. You're gonna get this thing built, and they're gonna finish their contract, because that's what you have contracts for. The question here is, who's the third party not in the room that we have to make happy? And that's the way to be creative. You don't have to announce that, okay? It's the guy outside the door waiting to see if he's gonna give you any more money. He's betting on both of you, okay? So it's not a question of who's responsible for what, it's just we're all in this thing together. And we gotta figure out a way how to get out of it and make the bank happy, okay? So that's an important element when you get in these kind of negotiations. Be very careful in quoting the law and what you think the law is. If you don't know what it is, you know, don't leave it to the other side to tell you what it is. And the second thing is, I would never ask the other side, well, do you have any more information I don't know about? Believe me, if they do, they'll tell you. If you ask them that, it looks like, oh gosh, have they really done their homework? Maybe I got an advantage on them. You know what I mean? That they don't really know what's going on. Maybe I do know more than they know. Don't ever ask the other side if they know more than you do, okay? Because they'll tell you if they don't, and it'll be part of their technique, and you have to listen very carefully. The last thing is, I think you did a pretty good job of listening to what the other side was saying, okay? So you can come, you know, coming up with creative ideas instead of announcing they're creative, they're self-evident. They'll think it's creative if they can work. If it's not work, it's not creative. It's just a waste of time. So, you know, that's part of the other negotiation. I come from that from a very practical aspect of it, that everybody is there for the same reason. But all in all, I think considering how little time you had to study the problem, you didn't have much time to do research on statutes. We fully appreciate that. So these are suggestions for the future, because before you go into this thing, you know, in my law school, the mantra was always the best prepared person almost always wins. And I've always believed in that. That's the way I practice law. But the important thing is, if you're the best prepared people in the conference, you will win.
Okay, I agree with everything that my colleagues have said. This is a competition, and there's some things that are just unique to the competition. But I thought you had good, insightful comments and questions that were to the point, get at the point questions from them to you in terms of what were you doing, why. So the self-evaluation you want to do constantly. Now, the other thing is, as was indicated, legislation has become a lot more important than it had been. And while it doesn't seem to always be emphasized, that's getting to be just as important as just going to court, and we're talking to good, but that's all part of the background. Very, very important. I want to make a couple of comments, not really tough ones, but style, grammar, and professionalism are very important. And I want to emphasize grammar. I asked my students first year, which is correct, between him and me or between him and I? 3/4 of them say between him and I. And I, boom, boom, boom. I mean, you know, if you remember Khrushchev in my time, he banged on the table at the UN. No. And as was stated before, you need to know that. And I say that because of the 3 words I use. I said style, but also professionalism. You are attorneys and you represent that. Another thing, amongst the teams, with your team, I was thinking, who was the tough guy and who was the nice person? And sometimes that's a technique. But I think in terms of the opposite team, that needs to be modified. And I got that impression. I made that comment to you earlier. I will say this as I close out. You all are 2 of the 4 final teams. I mean, you are 2 of the 4 best teams in the country. So that's how I close that out, and I think you did a very good job. But this is a learning situation for you, okay?
Do you have any questions for us?
Thank you for the
Thank you
feedback.
for the feedback and advice.
Just let me tell you a quick story. When I was in law school, we had to stand up on a site, and unfortunately, my professor, who later became dean of the Emory Law School, was an English professor before he became a lawyer. And I got up there and I said, my analyzation of the case is, he said, what did you say? I said, my analyzation of the case. Mr. Taqatqa, there's no such word, sit down. And that was the end of the last time he ever called on me. So I want to tell you, it happens even a long time ago. If you use it, a word sounds right, sounded right to me, no such word. So it's exactly his point.
Thank you all very much.
Thank
We
you very
appreciate
much.
it.
Thank you, guys, appreciate it.
Thank you for your time.
Thank you.
Thank you so much.
Good luck, all
Thank
of
you.
you.
Thank you so much.
Thank
Thank you.
Very nice.
Good luck.
I think our
Thank you for
profession's
your
in
time.
good hands if you all, that's
luck.
right, the next generation of lawyers.
Thank you very much.
Thank you very much.
Thank you.